Well, I'll go ahead and review the ground rules. I'll kind of skip the PECPA start at the beginning and just start with parties agree that whenever possible, statements to the board will be a joint presentation for the purpose of publicly stating their positions on open articles. Any unopened article by either party on May 31st, bargaining session will remain unopened unless mutually agreed upon otherwise. So I think we're good because I think we've opened just about all of them. Got a few of them that are closed now. But if either party opens an article, the entire article is open for bargaining and remains so until a tentative agreement is reached. First two bargaining sessions will be 2 hours in length. Subsequent bargaining sessions will be a minimum of 4 hours in length unless mutually agreed upon to be shorter in duration. 4-hour sessions will start no later than 2 p.m. unless mutually agreed upon. So this is our first 4-hour session.
All right.
Each team will indicate the estimated length of time of caucuses. If a caucus is taking more time than expected, a team representative will communicate that information to the other team during the caucus. Hobie and I talked briefly on the phone a little bit, and so we're going to go through all of the articles that we have to exchange before we caucus, even though the caucus part wasn't on the agenda, but we'll exchange all our proposals before we caucus. Tentative agreements on individual articles as they are reached will be dated with initials or signed by the spokesperson for each team with a copy for each team. We have one of those today for you. By the end of each meeting, an agenda for the next meeting will be set and action items will be assigned. Both parties are encouraged to share their priorities regarding issues or articles they would like to see resolved or seek clarification from either party. So I've been sending the agenda over. I hope that's working for us. And I did talk to Hobie about today being a little different in terms of going in chronological order. We can see if that works. I think it might give us each a break a little bit between having all one, and then all the other. We could even go to where we just alternate. It doesn't have to be chronological, but one side goes, the other side goes. So trying something new. All bargaining sessions will be open to the public unless mutually agreed upon otherwise. I'm going to come back to that one here in a second. All bargaining sessions will have a virtual option with a link embedded on the district's main webpage with the scheduled dates and times of upcoming bargaining sessions, so bargaining can be viewed in real time. And any time spent bargaining with the district when an employee is not on paid time will be split 50-50 with the employee. I don't need to go through the examples, and there's options there that we can look to if we are not on paid time. So I think that one and the bargaining sessions being open to the public, I'd like to talk about the email that was sent because
And just to be really clear, you're talking about the email that Vance sent to the members?
Yeah, that Vance sent to the members last night, because I guess, while yes, they're totally open, I guess for me and our team, I'd want to be prepared for that. Because if we're encouraging your members to attend, I mean, this is not a conducive space for a big audience group. And so, whether, we want to, at a caucus point, reconfigure the room so we can try to create an audience area. I think when the district hosts events, we take the responsibility of setting up the spaces and making sure that happens. But I view these bargaining sessions is more of a kind of a mutual thing. So let's work together to how do you want this to look? How do you want it to feel for your members if you wanted to have more members present, and whether that meant caucusing at 3 so we could move to the high school, just trying to be more prepared for making I guess I would have liked a heads up that, hey, we really want to try to emphasize this as an opportunity for our members. How can we make that happen together? That's what I would have liked. Because one of the things we talked about in setting up in preparation of the ground rules was, kind of what's the priority? Is it members being present? Is it on paid time? What are the kind of priorities here? And sometimes those things are in competition with each other. So that's just, I guess I would have appreciated a heads up so we could have prepared the space together.
Sure. I was approached, after the last couple of sessions, how can I view this? It's not virtually obviously after hours, don't do it on the clock. And then, I was trying to I've only had maybe 15 people ask, but I don't remember all 15, so I sent it to all classified staff.
Sure.
You're gonna have to get buzzed into the office, right? I didn't mean for it to throw things out of sorts.
Yeah. I guess it's just trying to have us work together to prepare the space. We can
Sure.
take care of the door. It's just more, I just didn't want people walking in there and go, well, even, standing room or whatever. And maybe if we have a break, we can move a few of the chairs the tables out of the way, and we can maybe try to create a little tiny space for people to have some chairs, so.
I saw the email also. I just want to mention that, as leaders here, the way I read it was that the district didn't want people coming in, that we don't have seats for people. And so I would just ask that we think about that sort of thing, because that's how we took it. And this is supposed to be equal back and forth here.
Sure.
It's those types of things that I think do both of our sides a disservice. Because we should be coming at goodwill, and we do take our role seriously in setting up the space. So we'll always make room for your members,
Yeah.
our staff.
I know this circle thing is kind of, it's obviously a couple years old, but, in the past, we've done it face to face, across the table. Maybe we need to go back to doing it that way for.
I mean, for the sake of,
It's worked in this room before, so I didn't really.
Yeah, we might be able to
see
do
that
that
as a
during a break,
problem. We'll see how many people show up.
Well, and I don't think that there was, I'll say from our side, there was no feeling from us that you were trying to exclude people. I mean, it's in our ground rules, right?
Right,
So-
it's just the way that we read it.
Yeah, I understand that. Just letting you know, that's not how we meant it. Yeah.
Yeah, just trying to, the invitation just is like, whoa, we're not gonna be ready for that, is how I.
Sure.
So, and then, the kind of the response to the district, that's, appreciate Scott saying that, because that felt like, okay, now I'm trying to discourage.
I wasn't sure how to word it, like,
Yeah.
hey, by the way, I didn't want to come out like, these guys don't want you there, because that doesn't seem right, but,
Yeah.
hey, they mentioned this to me, and I just quoted it straight across, because it's
Next
easy,
one's
copy and
gonna be-
pace.
What's that?
The library though, right?
Right.
In the high school.
Next one will be at the
Starting next
library.
week.
This whole thing's probably a moot point moving forward, because people will be off work, so it's probably a one and done. So. And then Scott wanted to share some
Yeah.
thoughts in regard to Article 29 safety.
Sure.
Well, I want to get this just off my chest, because I heard this last meeting, Hobie, and I'd like to ask that when we talk about kids, we talk about them with the utmost respect. And what I heard you say was kids coming back to us as feral cats.
That was a categorization from somebody else,
Yes.
but yes, that they're coming back after being locked down with a lot of problems and kind of
I know.
hard to manage, yeah.
I just think that, there are customers that the only reason why any of us in this room are here in this district. And we just need to talk about them as if we give them the utmost respect. I wouldn't want my kids talked about that way. And so I just think it's a good reminder for us all, just that we need to keep it as professional as possible.
Sure.
And we do have, you'll probably see actually a change in some of our language. I don't remember which article was that we were working on that had some change in some language to how we talk about kids. It's existing language, so it's been there for a while, but we're gonna talk about that one. So with that, I think we're ready to roll. So, and we'll just, like we talked about, we can exchange. I've got all our articles here, so you can share your batch and start with two, and then when it gets our turn, we'll share.
Yeah, and I've got them all bundled together.
Yeah.
I'll send them to you separately when I do send them.
Okay. Thank you.
Thank you. So, and you're looking at this, you'll see, rather than kill some more trees, articles where you came back with current contract language and we had our proposals, you'll see a very shortened version, just so you know what's going on, because I didn't want to print them all out again, since you already have them once and digitally. But 2, 9, and 10, I mean, we didn't have anything to really work with because you didn't give us anything back but the current contract language. So we're still on those same proposals. 11. So
I would like to be able to, and I have no problem with you not killing any trees, and if we want to kind of, we're going to take that same approach when it comes to 29 and 30, so
Sure.
if we want to mutually agree that if we're not changing, that we're not going to also kill trees, that'd be awesome.
Yeah.
But I would like to be able to go through then your previous proposal and be able to talk through or better understand why you're proposing what you're proposing. Is that possible?
Yeah, it's possible. Give me a second to pull it up. I think you'd have to take the lead on what you want clarified because we all
Sure.
have it all in writing there. So
I can do that.
let me pull it out. All right. Article 2 is
So
up.
So in the recognition Article 1, so it hereby recognizes OSEA as the exclusive representative is defined of classified employees excluding, so you have you're excluding licensed teachers, supervisory, confidential, work experience. So current contract language says temporary and substitute workers. And so I'm just not sure. So tell me about why you want to have substitute workers into your membership and how that's different than temporary. And I'm not even sure if I'd have to look at the statute to see if that is even within the ORS, but tell me about how you go about representing substitute workers.
So as I assume you're aware, in the history of doing this, the substitutes used to be based at the schools. In fact, I think we had some discussions earlier in the year about, not about necessarily doing that, but kind of how that worked in the past and whatnot, maybe how we could make something work for the future. So how would go about, assuming if the bill does not get passed, and it's, in my understanding is it's stalled at the moment, but if it does not get passed, then, we'd maybe have a slightly different discussion. But how it would essentially work in our minds is you'd have a list of people based on usage that would be tied to the school, right? And then they would, much like a hiring hall, which you've heard me I think say this before, they'd be utilized in order of longevity with the district and then also in availability, right? So we're looking at how that might work for folks to come in and maybe create a more stable pool for you. Because I know we've had trouble here and other places getting regular substitutes. If we have a way of putting them into, maybe getting some extra benefits, maybe we would be able to hold some of those folks and have them available for folks when they're gone. Because a lot of times you just don't have subs, or at best you're getting it for part of the time. So we're trying to figure out a way to make that a better, more feasible option for the district.
So I'm just not sure how we would even, identify when we have, so we have temporary employees, which could be, based on current language, could be either because they're filling in for someone who's on a leave of absence, or we also have this 90-day language here. I'm just not sure how many days would a substitute worker have to work before they would have eligibility, and I guess that's my first question.
Yeah, no, I think the problem that I see here is that temporary had a very distinctive role of, hey, you know what, we normally run with 2 maintenance people during the summer, but we need a 3rd person because that's when the lawns grow and the bushes need to be trimmed and other watered and different things. So we might hire for, from the end of June to the mid-August, we might hire a 3rd person. that would be a temporary worker, right? The work does not exist year-round for them, right? I think that that definition's been kind of fudged to be like, well, we're going to cover this position for 90 days or whatever it is, which really is not temporary work. It's a job that exists, right? And so back to your other question about substitutes, that seems like where you would use a substitute. And I think there's going to have to be some more in-depth discussions about this, because with PLO coming in, I see that as creating another situation where you have people gone for up to 3 months, right? And how are we going to handle that exactly? It would be the cleanest way, in my opinion, to take temporaries and really just put them back to what they're supposed to be, to cover those kinds of jobs. Like I gave the example, have a discussion about substitutes and how they would work and how they would cover and at what point they would become members, that kind of thing. And then have your regular probationary employees, right? That seems like a bigger discussion of those three pieces. And we're having that in a number of areas other than here too.
So how would a substitute employee view having to be a member of a union in this district if they're not required to be a member of a union? I mean, to me, it just, and I'm not trying to make an anti-union statement, I'm more thinking of another layer to, they can go sign up to be a substitute in Mount Angel or Salem Kaiser, but if they come to Silver Falls, then they're expected to join a union, when I doubt those other locations are going to have that.
Well, I would say that they would fall under the same laws as everybody else, so they would have the option to join the union. But the piece that I think actually could work to the district's benefit is that because they're willing to give these folks, we all know, bounce around different groups, just like you're explaining. But if we give them more of an incentive to be here, that they will come here first. You'll give you first bite at that apple, an ability to fill your positions much easier is the idea. So those other folks will then start missing out, and maybe they will have to adapt to that and do something different. But that's the intent, is to try to make it a better system that works better, so you have more reliability in that system. Because as I'm hearing it from our folks, it's not very reliable. It's hard to get subs. It's hard to find people. So I guess that's the one positive that we see coming out of this. But I do believe it's a bigger part of the discussion, and maybe that's something we touch on in a work session or something, about temporary versus substitute versus probationary, because I do think that those lines have been muddled a lot, and we've kind of got people doing things that just don't make sense. And don't make sense by the definition of what these words mean, don't make sense by the application of what's being done. And honestly, I think it restricts the district a little bit in certain scenarios to use substitutes in a way that would, like with the new PLO coming in, how are we going to figure that out, right? I know that's part of bargaining here, but I think there's a lot of room to have that discussion and figure that out.
Well, which I think leads into the next thing. If you go down under 3, on your proposal 3, and I guess it's the Roman numeral 4, is, reducing the temporary
days.
The temporary days. I mean, I think with PLO, we're actually going to need more temporary employees, and we're going to actually need to have a bigger, we're going to need more days, because bringing people in to sub for our employees who are entitled to PLO, we're gonna need a bigger pool of temporary folks. And so now, based on this language, we also, if somebody has the rights to the job, they would still fall under the temporary category. But it'd be pretty rare that we would bring, we would bring anybody in for 30 days and through a regular employment hiring process. I think if we're talking 30 days, we're probably talking a substitute posting. If we're talking, I'm not sure at what point we kind of cross that line and go, it looks like we better post for a position. I don't know, what do you think the average is, Kim?
It really is based on the information we have available for the vacancy. So if somebody tells us they think they're out 3 weeks, we're not going to be able to get a job posted, find an applicant pool, and get it filled for that duration. So what's best for the students? getting that substitute posting out there, and filling that. So there is a case by case by case situation. If we know somebody's out for 6 months, then yes, a temporary posting, absolutely, we want that person eligible for, the same things that an employee would, because honestly, once we get them in the door, people want to stay here. So we do like the idea of that for both sides. It's good for both people. Let somebody try a district out and decide if this is my new home, because it's not just, it's a two-way street. Somebody may not enjoy working here, or maybe, they're not the right fit for that particular job. So it's kind of where I'm coming from, and I'm honestly concerned. Senate Bill 283 is fully amended. The third-party subs are not going away. That bill has been amended, so there is no elimination of the third-party substitute employer.
They are doing a study, correct?
They are creating a task force and creating a study and looking at those being run through the ESDs. That the employees, all substitutes would be employees of ESDs because of things such as PLO.
Sure.
You got to think, we now have a state program for transient employees, right? How do you administer an encompassing program for an employee that is at different places? So the Senate Bill 283, great summary on the task force they're building for the next 2 years. They're doing pay studies. They're doing great cost analysis to see what the impact has been on districts with the implementation of third-party companies and stuff. So yeah, that's all.
Yeah, that sounds good for the future. I guess two things I'd point out is as you know, Dan, proposals are proposals, right? They're not, but and obviously we'd like to see the 90 days go down for the simple reason that if we make temporaries truly temporary and not substitutes or not probationary, it makes sense to do that, I think. But I guess I'm slightly confused because you said you thought you might need more than 90 days, but you guys responded with current contract language. So is the thought that you could maybe make it work?
No, I think more along the lines of, it's crossed our mind as to how we're going to have more temporary employees, but I also think that language there also states that if somebody's out on PLO, and this current language also allows us to have a temporary position for which no employee has job rights. Now, it kind of depends on the position. With our EAs and SNAs, we've been more, it always seems like we need one. So we've been more apt to, we've got one right now that somebody's going to be out on a leave of absence for all of next year. Well, we're not going to post that as a temporary position, even though somebody has job rights back to it. We're going to hire that, we're going to post as a regular position. We're going to tell that person that, look, technically there is somebody out on a leave that may come back, so you may be in a different building next year. But, that's the kind of situation where, again, to Kim's point, it's case by case. That one, even though technically we could say this is a temporary position because someone's coming back, it doesn't make any sense to do that for positions that we always seem to have a need. But if it was Vance taking or we only have one HVAC, I'm not going to hire an HVAC person. Chances of finding a HVAC person, but you get my point.
Right.
So.
Well, I think we can have some more discussions on that. I know we have a work session coming up, but I do believe that we can balance the temporary substitute and probationary in a way that makes sense. If we dive into a little deeper and dig into things deeper and have more of a deeper discussion, the time will allow for here. But I do think that that's something that we can work through. And we are in a number of areas, so I've got some practical experience on how that could look too, so we could have that discussion. Right now we have a proposal, but we don't have any kind of counter other than current contract language. So that's why you're seeing what you're seeing before you. So.
Well, and I would say that when you bring up having work sessions, is I'm not opposed to that. Obviously, I've brought one up for the EAS and a job description, but I've got to feel like those sessions are designed to where we are like, we both feel like we're getting close, and there's some wordsmithing that kind of needs to better understand what the issue is, and maybe there are some ideas that can be shared in a small group setting that can get something done. But this would not be one that I would would want to do a work session on, because to be honest with you, there's more questions that I could ask around what other contracts do you see substitute workers within the recognition clause? I would say that even the portion around having people scheduled for more than 5 hours does, while yes, there may be a law around SNAs coming into nobody else has that. I'm not going to have a work session for something that from our position is not going to change.
And that's not, okay, so this is a good discussion, because I disagree with your version of a work session. I think that the wordsmithing is very much back and forth in this process. It's the intent of a work session when we approach those is to sit down, have some frank discussions about what, like you might say, Hobie, this is my concern with this section specifically, where you just want to have the discussion. You don't want somebody back later quoting you back to yourself. The idea is not to bargain. The idea is to truly understand what the fundamental issues are that we're talking about, because when you leave those meetings, when we understand what the other person's talking about completely, and we've dug into it deeply, then we can bring back more thoughtful proposals so that maybe they get us to where we need to be, get us down to where we're maybe wordsmithing a little. That's how we utilize them, and that's I think the best way, because at the end of the process, usually you are just down to those last few words, and you're trying to, and quite frankly, that can be back and forth across the table. I guess you could have a work session for that, but that seems very minimal. We're trying to take the big amount and filter it down to the core of understanding exactly. So that way you can legitimately sit there and go, this is what this will cost us to do this, or this is how this will affect our group. If we, based on what Vance and Hobie and the team are saying, this is how this will affect us, and this is why we're worried, right? And we can do the same. That's how we see those work sessions. Because when you have a lot of things, and granted we way more than 2020, but we still have a good amount here. But a lot of this stuff, I think, through some simple discussion, especially the whole substitute, temporary, and probationary piece, I really think that could be drilled down on in a work session to where we can truly understand what we're trying to accomplish and see if it makes sense. If it doesn't, then we've got our proposals, but if it does, then we can come back with a more thoughtful proposal that would meet the concerns of whoever has those concerns.
And I guess for me, like on this particular one, is that I think it's important that, one of the reasons why we agree to have them recorded and out there is that, we're articulating our philosophical position on these issues that I think, people should hear about. I'm not worried about someone coming back and replaying something I said about this, and so,
Okay.
I think I think on the work sessions it just need to be case by case. We both agree that this is one that we think that we could get done. I think later on we're going to be on our training proposal. I'm hoping we're going to get kind of closer on that one. We've got some new language for that. I think we both have mutual interest in creating a professional development pool. We'll get to that, but that would be one that I could see us working on because we both have a mutual interest on this. On this particular one, I don't think there's any mutual interest from the district to change the recognition article.
Sure, and there's no need to do it. We can do it through this process if you want. It really is just trying to save time. It's not trying to circumvent anything.
So that's 2. So the next one, so 3 and 4, which obviously we both said we were tabling until the 21st.
Yeah.
So I wanted to have just a brief discussion on that. So on the 21st, we will be making a presentation with you that will support our initial economic proposal. We'll also be covering changes or adjustments that have been made over the course of this current contract that we feel also support our proposal. So we will not be bringing a new proposal on 3 and 4. So our ask or expectation would be that either you would present a defense of your position or a counter proposal. We'll just be bringing you a presentation.
Yeah, we'll have a presentation for you as well. It'll be a little different than that. I would just say pushing across the table is all the defense we need for a proposal. Our employees are very clear with us what they feel they're worth. So we're not gonna entertain that. But we will bring you information that will be very helpful for our process there. We also are planning to bring, I believe, a bundle. Don't confer that with my team, but I believe we talked about bringing a bundle so you can show you some different things, give you some kind of ideas what we're thinking about. And obviously, if you don't agree, it goes poof, but
Yeah.
at least you can see what we're thinking about. So that's kind of the thought process that we, as a team, I believe that, I've got that right, yeah, as a team that we're going to be showing you there as well in addition to our presentation.
Great.
Okay.
And Vance, you had sent me a kind of record request, or do you want just a list of districts? Is that all you wanted?
That's it.
That's it.
I can get that to you today. All right. So here, so Marissa, all they have to do is each person takes one and passes it.
Takes one down and pass it around, huh?
All right. So, and then I've got some,
Do you guys have yours? Because we have, oh, wait, no, each one's a packet.
each,
Each one's a packet.
So you thought those
I
directions were
should have
clear.
given Ron.
Oh,
Yeah.
One packet.
There you go.
Gotcha.
And Marissa did have, so I've got signed copies here, or copies to be signed here for 8.
Okay.
So 8 just had, was part of your grammar changes, so we just went
Yeah.
through, identified those, put okay, so that one should be easy.
Okay, finally, I knew there was one.
And then you had, so your 9, you said no changes from previous proposal.
Correct.
We went ahead and gave you the paper of our previous proposal, so,
Yeah, I think we're pretty.
so moving forward, do we, if we're just, for the sake of paper, do we just want to say previous, the date or the name of the previous proposal?
Or just even when I put theirs, I mean, we all have them electronically in paper, so it should be no problem. I think that would be helpful because then we don't burn down a forest to do this process.
Yep. So on your proposal, so starting in the first definition section,
Mm-hmm.
So you've crossed out for one or more of the causes listed below.
Because it's been struck down below too and redone.
So I guess I'm just curious as to, so I guess that begs the question is, so why are we striking out things that could, specific reasons why someone might get suspended? Or I guess, in the case of, if we took that further, striking out the section where it says should be a non-probationary employee may be discharged or disciplined for the following causes. So why are we striking reasons why someone might face discipline?
So, obviously in this proposal, I mean, if you look through it, the main thing we want here is just cause, right?
Mm-hmm.
And just cause speaks, we have it down below there, but generally it speaks to severity of the crime versus what the discipline is, right? The two things, so they match up. So I think the piece down here, a lot of this is old language that we'd like to change, but it seems cleaner to strike it and have the discussion. If we want to add in essentially what most contracts call a cardinal clause, where you have if you showing up under influence, for instance, right? If we want to have those discussions, if we're going to add those back in. Down here, when we have things like insubordination, unsatisfactory, or inefficient job performance, I mean, those are very subjective. If I say no to you about picking up something I drop and you tell me and I say no, and am I fired or am I suspended? I mean, it seems very, like for instance, in another contract we put in there, insubordination that, I remember the exact text, that where there needs to be a legal response or something like that. That's a higher definition, right? That's not a simple somebody doing something like I explained. So we're willing to have those discussions, but we do think it has to be something that we come up with together. So we're having those discussions that make sense, because the way it's written now, we just feel it's just unnecessarily vague in a lot of these issues. Some of them, down below here, like if you go down to V, misconduct for violation of published district policies, rules, regulations, or violation of state clerk. Okay, I can see some of that, but I mean, what are we specifically talking about? What's the violation of published district policies? That's overly broad in our opinion. You see what I'm saying? So I'm not opposed, and I don't think we're opposed to having those discussions, but we really should revamp them in a way that makes sense that we're talking about specific things. It would seem to me if somebody shows up here, and does something with violence, that's probably going to be one of those things you want to say that they should be fired for, right? And I don't think we would have a problem with putting that in here, physical violence or things like that. But we kind of have it, it's just very vague in a lot of spots. So we want to have that discussion. We want to figure out exactly what we're talking about, because not everything should be elevated to a level of suspension, Not everything should be elevated to a level of termination. So that's the idea behind this. And adding, of course, just cause, which I know the district is not interested in.
So I think over the life of this contract, I think we've done a really fair job of working through the current contract language that, that talks about the principle of progressive discipline, that we've had, gone through a process of written reprimand, suspension without pay, termination. Oftentimes it starts with making sure people were aware of the rule in the first place, so you have warning letters, which haven't been considered disciplinary, but at least lay the groundwork to make sure someone knew that there was a rule, because when you talk about policies, there's a lot of them. And so, it is important that maybe the less obvious policies, somebody gets, is aware of the policy that they violated. And I think we've done a really good job of making sure people are aware of those before moving through any kind of progressive discipline.
Well, and I guess that begs the question too. It's like, is warning letter, suspension, and termination, is that for all these things? Do you see what I'm saying? Like, is there some that are more severe that you want to terminate, or some that are less severe that you might want to have a 1 day and a 3 day suspension track instead of just a suspension and then move to termination, depending on what it is?
Well, I think you've skipped an important one there, and that is going from warning, which is not part of the disciplinary process. It's just really trying to bring attention to a rule. It's trying to say, hey, just so you know, this is a rule. And we're letting you know about that rule. And then the next step in the progressive discipline is reprimand, which the letters do read differently. The letters, a warning letter reads as that, is this is a rule, and we just want to make sure you're aware of it so that you do not face further discipline. Whereas a reprimand, there is a rendering of judgment at the end to say, in these acts, as a result of these acts, you are being reprimanded for these acts. And so there is a discipline component to it. So in most cases, we're trying to, you bring up insubordination, we're trying to tease out that can't versus won't. Are we trying to figure out, is this a can't because the person's trying to figure out, or is this a won't and they're not going to change their conduct? And so we're trying to figure that out before, and that's even before we get to a suspension, that is trying to, at that point, trying to say, okay, you've been reprimanded, and now we're to get your attention, because now we're probably thinking it's a won't, that we're suspending you without pay, and if you continue to conduct yourself in this way, it's going to be a termination. And so we've had very few terminations during this contract, and I think that we've exercised a lot of opportunity for people to learn and get better before we ever get to that place. So I think that our current contract language has served us really well in terms of being clear about what people can be disciplined or discharged for, and that we have a progressive discipline system that's worked.
So I understand the district's position. I think we disagree that it's worked as well as you would like. But rather than go down that rabbit hole, because those are opinions, I don't think we're going to get there. Why don't we talk about just cause, since we're talking about this article? So I'm trying to figure out what it is that the district objects to. So number one on here is fair notice. An employee may not be disciplined for violation of rule standard whose nature and penalty have not been made to the employee. So you say you do that already. So I'm not sure. It doesn't sound like we have a problem with that one. Prior enforcement, employee may not be penalized for violating a rule or standard that the employer has failed to enforce for a prolonged period. Again, sounds like you're saying you guys do that. You tell them and you issue the written warning and then you give them the reprimand letter. So I'm not seeing a problem with that. The due process, which we were just talking about, employee must be conduct an interview, a hearing, or before issue discipline and must act promptly. Once addressed, discipline may not be increased. Sounds like you're not doing that. So that seems like something you guys could agree to. Substantial evidence, charges must be proven, incredible. Well, of course, that seems like a no-brainer. I assume you're doing that. And then equal treatment, under 5, unless valid jurisdiction justifies a higher penalty, the employer may not assess a considerably stronger punishment against one of the employees than against another known to have committed a similar offense. Now, I don't know if you're doing that, to be fair, but I would assume that it makes sense that we would give everybody equal treatment. And then under 7, progressive discipline, again, you were just touching on this, responding to misconduct is short of egregious, very serious. An employer must issue at least 3 levels of discipline that allows the employee the opportunity to improve, which we had below, but we'd be interested in making it situational versus just absolute for everybody. But it sounds like you were talking to that point exactly. Mitigating and circumstances, discipline must be proportional to the gravity of the offense, taking into account any mitigating, existing, or aggravating circumstances, which I think you were talking about there versus can't versus won't. Whereas is somebody just not going to do this, not going to change, or that seems to play to that exactly. So I'm trying to figure out the reason why we can't have just cause in this contract. What does the district gain?
So before I answer that question, and I will answer.
Please do.
Do you have any other contracts where they list all 7 tenets of just cause?
Oh boy, I think I might have one that has them listed, but they're much shorter. They don't have a definition.
Got it.
But most of them say the words just cause or will not suffer, punishment without just cause, or they have mentioned just cause. And if we want to have that discussion, we'd be open to doing that, since we've reviewed them here.
Yep. So I think the reason why the district does not support having the just cause standard in the contract is the same reason why with teachers we did not want to remove the fair dismissal board from their contract. And the reason that is because they're sort of similar in that is that the path on this is to arbitration. And when you go to arbitration, you're probably getting an arbitrator from Wisconsin. And so you have this outside person that we have no case law for. We have no, we have no real kind of predictor of whether the just cause standard is going to, this person from, some other state, because I don't think Oregon has any, is going to come in here and going to determine whether the just cause standard was met or not. And so I think that while you made the point, we might not just, agree on this, is I think that we've not had any of our disciplinary action get grieved through the board over the life of this contract. So we don't have a history to saying that we've got these employees marching up to the board to have their case heard, depending on whether the board supports a decision to dismiss or through a grievance process. So I just don't see the problem that we have when we have no case law, local case law regarding grievances over discipline, needing to have an extra layer that goes above the board to arbitration. And if we had all these cases that over the course of this contract that said, we've had to take, all these cases to arbitration, Dan. So again, I just think it's more of a philosophical position that having an outside arbitrator measure a just cause standard in a contract is, you know, is appropriate.
So I guess I would say to that is that, you know, it's never, you know, a huge thing until it happens to you, right? And then all of a sudden it's everything. So I disagree that it's philosophical. I've seen a number of cases that I would say recently that I would say that this would be helpful for. But regardless of that point, that if we bring an arbitrator from Wisconsin or from Timbuktu, it doesn't matter. They're going to look at the facts of the case. And if it says just cause, it doesn't matter what we have here locally. It doesn't matter if there's buckets and buckets of settled law on what the tenets of just cause are and what they mean. So they will have access to all of it. And I suspect both of our proposals from our attorneys with the write-ups would have it in there too. So I don't think that that's a real reason, no offense meant by that. I feel like you have something that most districts don't have and you want to hold on to it, but I don't see how it stands up in the 21st century to being fair. I just don't think it's fair to our folks. I don't think it's fair to you guys. I think you're gonna get sued eventually. But regardless of that, it just seems like something that costs you really nothing and allows you to have a list that's very fair for people to look and see were these things done by both sides. If they weren't, we've got defective just cause, we need to have a discussion about that, right? If they were, and the person goes away, that's what happened, that's the process, right? That's the process. So I agree, we're gonna disagree on this one, but I think it's a good discussion. And I do think that those points laid out are extremely fair and clear. And I tried to make it as succinct as possible. But you're right, most contracts don't have that. They have either the term just cause used in it a number of times, or they have it laid out by bullet points or spread out in a paragraph. So there is that, you know.
So team, do you have any more questions on that section of anything? I have another question on.
I actually have a question.
Go for it.
Under B, it looks like you want to extend some of these calendar dates here. Can you just elaborate on that a little bit more?
So on our last proposal?
Yeah. Under June, well, it says June 5th, but yeah, it's the one you just handed us.
Yeah. Let me.
4B,
Yeah, 4B, that's it.
thank you.
Well, we're looking for that.
So 4B, yeah, so, you know, sometimes we have these, well, the first thing I want to point out on this one is that current contract language has the first set of days as working days, and then the second set of days is calendar days. So one way or the other, we need to have the same number. It needs to be the same. So
Why?
why? Because it does make a difference in terms of how we calculate those things. And you know, at one point, you know, when you're talking working days, I mean, for us who oftentimes do this work on the weekends, you know, we're taking those things into consideration as we're working through those things. And so I think it just creates confusion, and when you have one paragraph where one sentence talks about working and one sentence talks about calendar. So I think we should be definitely working from the same, how we get out our calendar and we count 1, 2, oh, don't count the weekends, 3, 4, 5, 6, 7. Oh, this time we gotta count the weekends. So I think it needs to be, you know, one or the other. I'm open to kind of one or the other, but it needs to be the same. And then I think some of these things, you know, we had a situation this last year where we had mitigating factors. We had accessibility to employees to conduct investigations, and you know, and in one case we were ready to issue a letter and the employee wasn't available, and at least the conversation, we got it worked out. But at one point it seemed like there was going to be a lack of flexibility, that the access to the employee didn't change the fact that the district had a deadline to meet. And thankfully we were able to work through that, but it kind of gave us a little bit of a pause of, well, if that's going to be the standard, that we need to stretch our time out so that we don't encounter factors outside of their control. I think the intent of the language is, district, you need to get down to business, that you don't want this person hanging out there waiting to know whether they're getting disciplined or not, right? And isn't that the intent, to make sure the district's, moving through this process?
Are you
So-
asking a question, or are you just?
Well, yes.
Okay, I would say yes. I do think, people, anybody who's ever had to be off, even if it's not their fault, on administrative leave, it's stressful. Sure, we want them to move through the process, but I would also say that your scenario could happen with this too, technically, with these deadlines. I think the key takeaway here is that you reached out and we worked out, I think we extended that timeline. We worked with you on that because of the scenario. The second thing I would say is that, we have work days and calendar days. We can look at making them standard, as long as those were agreed to the way they were agreed to for various reasons, right? So sometimes work days are important, and sometimes calendar days are sufficient. So I think we could have that shift, but we would have to have more of a discussion about how that would look, so that we are trying to keep with what we feel has worked well, largely for us over the years. So I don't say, I'm not against having that discussion, but we would want to make sure that we bookmark it with that the working days thing in certain sections, I know I'm very familiar with because I put some of that in some of these sections, because it's just very clear, right? And yes, other areas it says calendar because it's something that's, a little simpler to follow for some people. But I can see what you're saying about it being hard for everybody to keep that straight in their head, and that's a fair point.
I can say, I apologize for stepping in, but the working days has been a concern due to the significant number of different work calendars. So there has been some question about working days. Whose working days then?
Didn't we resolve this last time by the days the district's open? Isn't that what we did? Or the
It's
school's
not
open?
they're asking me to point to where that definition is of a work
I'd have to
day.
look it up. Yeah, I could
It's
swear we
not,
had this
but it's not in
discussion.
our recognition, we don't have a definitions article, we don't have a, so I'm just giving you the feedback of where we're
Sure.
coming from, trying to find a way to define something, so there's no question about whose days we're talking about. So
Yeah,
that's
it's great
just
thing,
the source of
because we
our-
actually talked about, do we want to do working days on both, or do we want to do calendar days on both of these? I mean, we didn't really have a super strong preference, but that ended up being the reason why we went to calendar days is, and a little bit longer, is if we hit a winter break, and an employee is off on those days, because I think we went with the idea that if the district's open, it's a working day, even though the employee is off. And so I think that was another reason why we wanted to extend the time, is so that, because we don't want to bring an employee in off a break. And we also don't want to be, if we're holding up our end of the responsibility to do a timely investigation, and this doesn't mean that somebody's on paid admin leave, it just means they're awaiting a decision. Obviously, if they're on paid admin leave, we want them back as soon as possible too. So again, I think it's about us wanting to get to the end of a conclusion, but also not wanting to be held up in our ability to deliver a decision for things outside of our control. That's the reason why we're wanting to extend the time, and that is the reason why we want calendar days, is we want to be able to say there's no ambiguity about whose working days that we're talking about. We're talking 21 calendar days. So.
It's kind of the reason we want 30 days for grievances too, I think, for similar reasons, but I understand.
So on yours, you have a D there that if an employee makes the district aware they intend to file a grievance over a suspension, the employee shall not serve the suspension until the grievance process is completed or they have been found in violation. Where else have you ever seen that language?
Oh, it's in quite a few public contracts. I don't know of any other district off the top of my head, but I believe firefighters and police and a few other groups have that, if I recall correctly. I know they do in Washington.
Well, I would be interested in any school districts that allow any discipline to be withheld. I mean,
Not discipline, it would be unpaid leave, is that what you're talking about?
well, I think you also had in your grievance article, I'd have to go look, and
Sure.
I think in your grievance article, you had a kind of a thing
You're
there
talking about
where-
them not serving it until they are found guilty, is that what you mean? That's what D says.
Yeah, but even that, I thought maybe you had it in your grievance article too, but either way, I mean, kind of I don't know any school district that has this, and I mean, kind of the whole process has been, it's kind of work now, grieve later. I mean, you do this, this thing happens, and you go through a grievance process, and if you win the grievance, then the employee gets paid for the days that they were suspended. I mean, that's typically how it works.
Well, no, I understand your position on that, but I would say that that's a position. It's definitely not the only position. I mean, in a number of other fields, to be fair, I have seen this language because the grievance stops it in its tracks, because why would you be punished for something you already, because see, you can make the argument, we'll pay them later, but they need their bills paid this month, and it may take 3 months to get that done. Whereas, if they lose and that 3 months later, then they would serve the suspension. Does that make sense? I mean, that's the intent behind it anyway, if it's not clear in there. Is that if they file a grievance, then we put it on hold, but like doing investigation, then coming to meet with the employee on a Tuesday and saying tomorrow and Wednesday and Thursday you are suspended, I mean, it just creates a lot of havoc in people's lives. I've not seen that anywhere else. So usually if they're gonna suspend them, it's put out a little bit so they can plan for that and whatnot. I've never seen it the next day like that, except for here. So that is a difference there. But the idea being is that why would you, if you're disputing that you're guilty, why would you pay the price now when it turns out you may not be guilty when the process is complete? That's the logic behind it, right? And also, like I said, with no planning or no way of knowing, when they're just literally called in the next 2 days, they're off without pay, it's hard for people to schedule their lives and pay their bills when they can't plan for things like that. Whereas the discipline is the discipline. If they're found guilty, they still get disciplined, right? I mean, that's the intent, I guess, if that's helpful.
Just wanted to clarify what you said, and you're referring to only suspension without pay then?
Of course, yeah. If they're suspended with pay, then they're not suffering a harm here. They may still disagree, and they still might take it through the process, but they're not suffering a harm there.
Just wanted to
Yeah.
clarify.
Yeah. Yep.
Thanks.
So that's a good segue into Article 10, the grievance procedure, which you're proposing your previous proposal.
Correct.
So in the definitions portion, and actually in a few different places on there, you've crossed out specific. Why is that?
We've crossed out specific because it narrows the scope in such a way that, like, how do you file a grievance if let's say we have a safety article. Let's say we have stuff in there about unsafe equipment, right? We have a couple examples or something. But then we have something that's not listed in those examples or not part, but it is a safety concern. What do we do with that? Would we still bring it?
Well, let's talk about, maybe use language that we currently have in the contract. So I guess the reason why we want specific is that, let's say we are disciplining an employee and using, so we're using Article 9, we're disciplining an employee, and if the grievance says you violated Article 9 of the discipline process,
Right.
how am I supposed to know what aspect of Article 9 I say me, but the district, that was violated if we don't have a specific, when you didn't do this, or when you did this thing, you violated this specific part of the contract. So I just think that without the word specific in there, you could easily write a grievance to say you violated Article 9 of the contract, and we would have no basis to look, because I think we've had a couple where we go, yep, we'll get that one fixed. I mean, we haven't had many, but when we can go, yeah, we did miss a step, we would be quick to fix it. But if it's so broad, how would we move through?
And let's play that scenario out. I like that scenario. So it says Article 9. You don't know what part of Article 9 is what you're saying. So if we agree we're the moving party, right? We have to prove our case. So we have to provide you information saying, this is what we think the issue is, right? This is how we build our case, right? We have to have a specified remedy under this contract too, specific, I think,
Mm-hmm.
but a remedy regardless, which again would say, this has happened here, this is what we feel the resolve is, right? And so we have to prove, if you discipline somebody, you have to prove your case. You're the moving party. If we're the moving party, and we write you a vague grievance like that, and you come and say, we don't know what the hell we're talking about here, why are we here? And we say, well, okay, this is what we're doing. I mean, it should be laid out in the grievance, quite frankly. That's how grievances work.
Well, and that's,
But if
I mean-
it's not, if, let's say it wasn't, let's use your scenario, then you would rightfully say, what are you grieving? And it would be on us to prove our case. Because if we come to you with a vague idea of what's going on, if I was you, I would say, I don't see a grievance here, right? I mean, that would be the way to treat that. But I'm telling you that we would bring you the evidence, the case, and what we're talking about for a remedy, because that's what we're supposed to do. So I just don't think that, I mean, we've actually talked about this word specific in our caucus yesterday, actually, night, and we think we have some ideas on this, but the problem is that we don't have a counter from you even considering anything, and so bargaining against ourselves doesn't feel like a useful use of our time unless we're throwing it in a bundle or something. So that's part of the reason why whenever you give us current contract language and we have a proposal, I mean, it's hard for us to make movement unless we're putting it into a bundle and combining with some other things and shifting some here to put some over here kind of idea. So you're going to see that with some of these when we're just at, I don't know if we're totally opposed, but we don't have anything new on either side.
So then the other thing on this definitions page, you've basically added not only can a contract be grieved, but a complaint can be grieved.
Yes.
So
Yes. The reason for this is because every group that I've ever dealt with, when we don't have a process like we can file a grievance and really have a good discussion about things, especially things like safety, especially things like, that could go into other groups like BOLI and other groups that can come in and then dictate to us how we're going to run our business here on either side or both. That's what I don't want. I feel like we have largely worked through, even if we don't agree on everything, we've largely worked through things through the processes we have. This expands it so that we don't have, bully walking here saying, this is how this is going to work. Now, nothing stops them from doing that technically, but if the person feels they can come here and get resolution, we stop those complaints going over here and then losing control of what happens with that process. That's the intent.
Well, I mean, the way this reads to me, because we added the little sub-bullet under, let's see if we, let's double check here. So, again, so one thing we do need to talk about is kind of whose document we're working from, because I look at the purpose page and I don't see a sub-bullet there. I don't know what you have there. So, but.
Well, we established that there was a couple pages that got.
Yeah.
So
now that
we'll work
language
through
is in
that.
there, but it's just not part of a sub-bullet.
Yeah.
So that language that says complaints and concerns about issues other than alleged contract violations, that was added this last contract because you wanted to be able to broaden, or at least have people know. So if it's not a contract violation, but I feel bothered by it, what other avenues do I have? And so we added that.
We did
We added
in
that.
2020, yep.
And so, but with your addition of or other complaint there, so all of a sudden, let's say, I'll pick on Lisa this time. So let's say Lisa is upset about something, she can't find any contract violation over it, but she decides to file a complaint. And it goes through the process, the complaint process as outlined in board policy, and then it gets to Scott, and Scott, at each stage, Lisa doesn't get what she wants, and it goes to Scott, so now that complaint can be grieved. And so now we've just added a whole host of other things that are subject to the grievance process, which again, if it went all the way through to arbitration, we would have just a whole host of things that we couldn't even anticipate. At least with a contract, we have a very strong idea of what our boundaries are, what we're obligated to do, but if we open it up to the complaint process, that's opened up to you know, every employee could have its own interpretation of what should have or should not have happened to them, and then it could be grieved.
So, I mean, I know that's an overly broad example, but even in that example, I would say we still have to prove our case. We're the moving party, so we still have to prove our case. But I understand your point about them going through one process and going through another. I think that's a fair comment. We have other places in the contract where people can choose a path. They can go to the board or they can go to a grievance if they can't do both. We could have we could have some discussion about that. I think that's fair. Because you don't want to duplicate yourself. That makes sense. They got to make their choice and then live with the outcome from either way that it goes. But I do think that, I mean, I hear this about filing grievances, but the reality is that, you know, you've got to prove your case. You can't just, you're mad today, you file a grievance, you know. What do you get for that? You know, you lose at best. And likely, I'm going to tell you don't have a grievance because you don't have a grievance. But because we all try to follow, you got to make your case. I'm not going to stand up here and make an argument for somebody who doesn't have a case. They're just they just feel a certain way, right? So I do think that it's more likely that you will probably see, you know, people choosing, if we had a choice for them, going to one of those two processes. But I don't think it's going to like increase your grievance fold by 10-fold or 20-fold or even probably 5-fold, you know, from where you're at now. Because quite frankly, most people, if they follow this process, they're still having the discussion with their supervisor, right? They're still going through the process leading up to this before they file a grievance. So
Well, I think that it wouldn't matter whether it was 1 or 10. I think the issue is predictability, is that the fact that at least when it's a contract grievance, there's a level of predictability because we know exactly what's in the contract. But leaving it up to anybody who just has an axe to grind, you know, leaves us no ability to go, you know, what was violated other than you feel wronged, and you go through a process, and then they can still go through all the way to Scott. Okay, now we can come back around and we can go, you know, through a grievance. It can go to the board. It can go to arbitration over something that wasn't mutually agreed upon by these two parties.
So I guess I would say that, again, you could develop a dual track so that it wouldn't go through all those steps. They'd choose to file a grievance, move it forward that way, or they would go through the board. But either way that they do that, even with the existing language, you know, they have to, the grievance examples, and that's the one that seems to be more concerned about. The process is you bring it to your immediate supervisor, right? Try to resolve it. If it's not resolved, file a formal grievance, then we bring it to a formal, there's a process to go through. And we're not going to go through all these steps. I mean, you know, I got plenty of other things to do too, you know, than to sit here and go through steps for something where there's not a grievance. And so we have to prove our case. It can't just be, I have this feeling that I was wrong this one time. It has to be, here's what happened, here's the facts of the matter, and here's what I think is the resolution, right? That has to be the core parts of the grievance. I believe that's laid out in our contract as well. So I just don't, I hear what you're saying, but it doesn't seem tethered to real world events here, because those are the facts of what the process is that they have to go through. It doesn't matter if it's a contract grievance or a complaint or whatever it might be, they still have to do those steps. And those grievances get ferreted out pretty quickly, you know. I just had a meeting about something like this up in Amity, and they didn't have a grievance, you know, they just didn't. You know, it was a general concern, great, but it wasn't a grievance. That was the end of the process, you know, that meeting was it. So I hear the concern, I just don't see it based on anything that's really tied to anything that's really happening. I just don't see that, because we have a process in place to make sure that we don't have those things happen. But I would be interested in a dual track, because I do think that's fair, not having to go, they don't like what they get from this side, they come over here and start over again. I don't think that's fair.
I don't see a dual track. I just see the fact that if they did not have a contract violation, but they had a complaint. I mean, I could see this language being expanded to complaints against coworkers.
Well, we don't accept grievances against other members. If there's, I'm just saying we just don't, you know, it's not a thing.
I mean, you're not the total gatekeeper on those grievances. They could go through the whole complaint process, and you've said before that, you know, that now at some level it may not go all the way through to arbitration. I think that OSEA may say, we're not supporting this one.
Sure.
But those initial grievance places, so you could have a complaint against a coworker, and the person doesn't get the outcome that they want all the way to Scott, and they could still file a grievance because they're still, based on that language, they could still file a grievance based on the fact they're unhappy with how the complaint was resolved.
Right, and that's if we don't set up a dual track where they have to choose. So if we
But
put language in there.
I don't understand dual track because they have one track right now.
Right.
It's if the contract was violated.
That's correct.
They have one track. So they, based on the addition of that language, if their complaint against a coworker is they're upset with somebody and they want to take it, they can go all the way through the complaint process, all the way into a grievance process based on that language. That is one,
That could happen with this current language, the way it's written. What I'm trying to say here is that we're willing to look at it so that doesn't happen. If that's the concern, and see, this feels like a work session, because this is exactly what we'd be talking about, without taking all this time from everybody. But if you're concerned, if that is your concern, we could have a track saying, you have this option or you have this option. You choose one, the other is no longer open to you. We have that in this contract in another section for other things. So that's what I'm trying to say is you can set it up so that that doesn't happen. And we'd be willing to entertain that because we think that there's a valid point being made there. But after we offer that, as a possible discussion point, it doesn't make sense to keep saying, well, this language, I agree with your interpretation of this language. I wrote it, with these folks. But we're willing to modify that so to better meet your needs, but also give people an avenue to deal with it one of two ways. And this, I think, will save us time because, sooner or later, we came close to having a bully charge here a while back that we had, to the last minute, we headed it off, we had a dozen people going to file complaints, right? And we headed it off and we got it resolved and we worked through it with you and Lisa and everything, the night shift differential.
Okay.
Yeah, we had I don't know how many people, a dozen or so people to file complaints. That seems silly to me because it's for the record, bully is a very important group that we need to have around, but I would like us to really have the first crack at this stuff before it gets that far. And having somebody be able to file a grievance in that scenario would be a perfect example of what I'm talking about because we could resolve it earlier instead of having to wait till the 11th hour where people are filling out paperwork to go. It was hard to stop that train, and I just think this gives us another avenue to deal with these things in-house because when they come in and tell us, you're going to do this, we don't get a vote, right? That's their job, right? So now we both live with something. Maybe we get everything we want and you don't. Well, that'll make you happy, but maybe it's the other way. Or worse scenario, we neither one get what we want and we get something from them that they want, right? That's what I'm trying to offset here is give people a way to go through this process.
But a bully complaint is different than a complaint, utilizing KLAR, which we literally had a complaint last year against a teacher from her neighbor.
Mm-hmm. Sure.
Where, that's the kind of complaints we sometimes get.
Sure. I'm not sure, typically how we resolve these things is the complaint to your neighbor, that would have to go through you guys, because I don't know, we don't have a process even with this, unless the neighbor is the person that works here, right? I don't know how that would tie in.
Well, I'm just trying to point out sort of sometimes the absurdity of complaints, but based on this language, the ability of one of your members to file a complaint,
Mm-hmm.
and which they have every right to do, but if unsatisfied with the outcome of that complaint, could then take it through a grievance process. That's the issue, is that you get that complaint, it's out of yours and my hands. When they're not happy with it, doesn't matter how absurd we might think it would be, they could still go through that process. Now you might stop it from, OSEA may say, we're not paying for an arbitrator for this, but it sure would have taken everybody's time through the lower stages.
Except for the fact that we have deadlines in our contract from when the occurrence happens and when you have to file it. So if they go through that process and they miss those deadlines, they wouldn't be there. But again, you're speaking to what's on the page, which is fine. We're not disagreeing that if everything worked out right with the timeline and everything else, they could do what you're saying. What we're suggesting is that maybe if you showed us the counter that allowed them to pick between the two, and that's the end of the selection. We have that language later in the contract. You can cut and paste it. That would be sufficient and give people a choice to do this one or the other, but not both. And then you'd be able to do it.
What do other districts do? Is there language similar to this in other contracts that you?
There's language in this contract that's similar to this. It talks about them taking, I think they can take their termination to the board, or they can arbitrate, but they can't do both. I have to look it up, but I believe that's what it says.
It's specific to grievances.
It is specific to grievances, but it gets them a choice. But the point is the choice. They can either choose to go to the board or go to arbitration, right? That's the point. This would be a very similar situation. They could choose to do a complaint or a grievance, but not both. That's the point.
So do you have other districts that have, where they can file a grievance based on the outcome of a complaint?
That's not specific.
Non-contract.
Not on the outcome of a complaint. They can have the choice, I believe, to either take it through, or they can have the choice to file a grievance. But once they choose one, the other option is dead to them. I know many county contracts and city contracts have this kind of language.
I'd be very curious as to any school districts that allow people to go through a grievance based on the outcome of a complaint.
Why would school districts?
Non-contract complaint.
This is twice I've heard you say school districts. Why would school district employees be held to a different standard than the rest of the state employees?
Because, it's apples to apples. Why would we compare another industry to a different industry? We are very unique in our industry. And so to try to compare to another outside group that, I wouldn't know.
Well, I imagine, if it's a secretary that works for a police department, they're still a secretary.
Well,
I don't want to get bogged down in that. It just
Yeah,
seems to me like
yeah.
we should have the same rights as everyone else, not just held to the rights that other school districts may have.
But it's hard to have a standard when we're trying to compare, when we're trying to negotiate new contract. One of the biggies is for me to call an HR director and go, so how has this worked for you?
Mm-hmm.
So for instance, the reclassification language, McMinnville called me. They called us. And I said, I think we've got really good reclassification language that we added back into our contract there. And that's, a lot of it is to be able to call somebody and go, so Hobie's telling me that this has worked out great. I see you've got it. How has it worked for you? That's where I think the main reason is that it gives us someone to phone call and go, because if you told me that, North Santiam, I'd be on the phone to Danny Blackwell going, so tell me about this language.
Yeah, and that's usually why when I have the exact examples in my top of my mind, I tell you. But let's use your standard. So let's say that no districts have this language, so that's why you don't want it, okay? So the inverse should be true too. Eugene has substitute employees in the union, so I'm assuming you would like to talk about putting them in your group, right?
Well, I think comparing us to 4J, that's massive.
But Just Cause.
It Just Cause would be another example. Do you see what I'm saying? It can be played both ways. I just don't want to get bogged down in either, but the reality is this, that somebody leads the way and somebody drags behind. That's the reality of the world we live in. So some districts have, some really cool things, and you're saying, well, we can't do that maybe, but you have the ability to do some of these things.
I was just waiting for you to tell me, because usually what you say is, but Dan, you could be the first.
You can't. I said that last time. I don't want to say it every time.
So I was just kind of waiting for that.
And the other thing I always tell you is that just because they're doing it the wrong way doesn't mean we can't do it the right way. So, but I think you get the point. I think what you're saying makes sense on the current proposal the way it's written. I do believe there's room to make that proposal work for both sides based on the examples we gave. We'd love to see a counter for you on it.
Oh, what were you going to say?
Well, I was just gonna say, it's not fair either to cherry pick, right? The
Sure,
outliers. Like,
but you guys do it.
I haven't heard a lot of us doing it, but
I believe
just
that.
make that as a point.
Yeah, no, it's
When
a
you're
valid
gonna pick
point.
examples that are outliers are helpful to a degree, but they're not as helpful as, 75% of the districts are doing this, then to me that carries some weight.
Yeah, but if you use that model, we wouldn't have the equity law either, right? Because most in fact, probably hesitate to say all districts were not doing it that way, but we decided that was wrong and we changed it, right? So I'm just saying, I get what you're saying, but there's times change, things move forward. there's ways to make things work better for everybody. We don't have to be trapped by the trappings of the past. We don't have to have that happen. We can move forward in a way that develops something that works for both sides. It doesn't have to be one-sided.
Completely agree. I'm talking about as a matter of general principle. That's all. So there's definitely going to be exceptions, and I agree with that.
And I would, as I am more of the data side of things, I
Yeah.
really would love for you to provide us the information that we've cherry-picked. I really would, honestly, because it's important to me that we provide factual data on sets, so.
Just cause.
Excuse me?
Just cause.
Just cause we cherry-picked.
Yeah,
What-
more than 75% of your neighbors have that. You do not.
But I
There's
think
an
what
example.
Kim-
How can we cherry
but no,
pick?
I
You're-
think what Kim's saying is, if we throw out an outlier, we have not had just cause in our contract forever.
Sure.
So, I mean, we're not cherry picking that, that's just the current contract language. If you want to make the point that most districts have it, fair enough. I think that what Kim's trying to say is that if we've cherry picked
Any data.
any data that's just kind of the outlier or whatnot, we would want to know that. If
100%.
if we're proposing language that is obscure and not out there, we would want to know that. Not talking about our current contract language.
And
That's-
thank you, I
yeah.
appreciate that clarification, because it's important to us. We want to be as transparent as we can, factual based. A lot of the stuff I'm involved in, factual based. There's a lot of, I know, softer things that other team members are much more experts on, but the cherry pick, that was concerning for me. I very much like to hear that. And so, and I just want to share cross-industry comparison. I hear what you're saying. There's no greater value to one or the other, but I'm very worried about the negative impact that could have on our staff to lose health insurance for 3 months out of the summer, because they don't work.
And
So if we don't want to compare ourselves to school districts, find me another industry where you get 3 months off and your health insurance is covered.
construction, 6 months.
So
They get
it's an hour
insurance
bank.
for
It's
6
an
months.
hour bank.
It is.
Correct.
They front load it when they work.
And hour banks are a
and they
great
put it
idea.
in.
Maybe we need to look at hour banks. I
Well-
actually have considered that.
Well, let's look at our sick leave and
140
proposal
hours.
first,
140 hours a month gets you full-time health insurance in the construction industry, you're right. So times 12.
Well-
Unfortunately, you would lose health
Yeah.
insurance for most of your employees.
It's not quite that simple. It's not exactly full-time either.
It's-
But I don't want to get the ins and outs of a different industry, but there is
You're
other
right, and
things,
there's
yeah.
different
Yeah.
CPAs, different
Yeah.
industries, but I guess between the cherry picking and then saying, let's compare ourselves to different industries, to me, that's a cherry picking then if we're gonna compare one part of a different industry and not the other part.
Well, and that's fine. I mean,
Okay.
this is definitely going down a rabbit hole I didn't want to go down, but I will say this in general. I understand the lane you want to drive in, the guardrails you want in this discussion. We're just not agreeing. It's just that simple. We're gonna bring in what we think, based on talking to our members, what they want. You saw that with our wage proposal. That was very much, the members were very strong about feeling their worth there. But you're gonna see that stuff here, and we're not gonna be hemmed in by a different, and this is not directed at you, Kim, or at Dan, it's just in a general statement. We're not gonna be hemmed in by what you believe is correct or should be done the way it's done, okay? You have your side of the table, we have ours. We're gonna have these discussions, we're gonna have this good debate, because I think it's important. And at the end of the day, we may not agree to those things. You've been through a few with me now, Dan. No, I definitely didn't get everything that I wanted on the table, and I would say you probably say the same. But we'll find our way to that middle ground. But having a discussion is never a bad part of this, okay? Even if we disagree. It's just gonna be, we can have our opinions about whether it's cherry picking or not cherry picking or these different things. I think we lose sight of the fact that we're asking this question for a reason. You're asking this question for a reason. And we're trying to get closer to a deal, right? So I just want to kind of circle us back to that, because I think it's helpful. I don't want people to walk away. I've done this long enough. It ain't going to bother me, anything said here, but I want people to walk away upset thinking that we're trying to start an unreasonable fight here or something, We're trying to have the discussion.
Well, and this is the first 4-hour session where,
It is.
the first 2 sessions were pretty much just, here you go. And now it's time to dig
Have the
in
discussion,
and have the
yeah.
discussion. So if anybody else nobody else has any questions on Article 10, I'm ready to move on to Article 11,
All right.
which you have a new proposal for us.
It's a modified proposal. So now, I know you guys haven't been doing the colors, but I think the green is where we've agreed. They're largely
Okay.
simple grammatical things, but I'm just trying to make it look like, these are the things we don't have to really worry about anymore. But nothing's done until it's all done. So I guess my question on number 2, we left that in there. We're trying to figure out why this would be something that the district would not be interested in. Just so people can come back
As far
on the
as the
calendar.
no later than
Yeah.
August 15?
Don't you guys usually have this done end of July, start of August? So that you can give people their calendars emailed? Is the date the question, or is it just you don't do it till they come back and you hand them their schedule, or do you want to?
So how, the number of days we
Yeah.
required to work, so
So when did
I'm
we,
thinking like inclement weather days, I mean, I guess.
well, we send out, but
Yeah.
employment calendars typically go out by a certain time.
That's what I thought. Yeah.
Yeah. So that's
I mean,
what
we
you're.
usually try to send them out
you're
before
talking
they go
about
home
their-
for the summer.
Yeah.
That's
Yeah.
You're talking
that's
about their work
calendar. So
not their assigned work days, their work calendar,
The-
how many days their contract is for, correct?
no, I think we're talking about the calendar. Like these are the days you're working.
So that gets tough due to, I mean, all the pieces that this would then touch, right?
Sure.
Because as the board adds days, we would need a right to be able to change that.
Well, let me give you an example. So you got it all done here. Let's say the start of August. You send it out to everybody with inclement weather days or something like that. Obviously, that's going to change things.
Okay.
That's not the intent of this. It's
Okay.
just so I can see. Oh, this is the week. They decided to take an extra day before spring break. Now I know that, so I can make a plan. Right? That's the intent of this. If that's helpful.
Yeah, I mean, I think we almost send them out twice. I think we try to send them out at the end of summer and then, or like right around now. And then we usually in early August, remind people, hey, here's your calendar, don't forget, especially for our EAs and SNAs, sometimes their start date, is a little
Different.
different each year. So is that kind of the intent behind this, is to make sure like those folks get at least like a 2-week notice?
Yeah. They just get
I
their
know
calendars
Nancy
so
brought
they
that
can.
up before,
Yeah.
to me, is like, hey, because we've changed it a couple times,
Yeah.
and like, what if somebody already has plans,
Yeah.
kind of thing. Okay, well, that helps us understand that, I think we can
Okay.
talk about that.
And then the green, I believe, is like we separated out employees. We separated out like you did. We just made it green, even though it's existing language. But we made it so to show that change had been made. Down below is the same proposal, and we kind of touched on that. I think in another proposal. This is in like 3 different places in this contract, so
Right.
you're gonna. we can dig into it, but it's pretty much gonna be the same conversation. And I think that's gonna be something that we might be able to work on later. If you turn the page, you'll see that it's pretty much all green there. And then that's all we have. So this one's actually fairly close, I think, except for that one section, the 4 hours versus 5-hour employees and so on.
So in 3A, we did make some other minor modifications, I don't think.
Oh, right. We did not reflect these here? Okay, yeah, good point, Dan. We're not agreeing, we're agreeing that you have the ability to shift them 30 minutes. But we're not agreeing that it's something that, if it doesn't change their hours or whatever you had in there, we weren't agreeing with that. We don't believe that's the practice either, according to my team anyway. So, and did you want to speak to that a little bit, Vance? 3A?
So, I guess my concern is, at what point are you guys changing their hours, this 30 minutes, right? Like, is it Monday and you say, hey, Friday, I need you to do this? So, I just don't see it.
We don't feel it's been applied that way either. I mean,
No.
the only conversation that I can even think of, we had somebody where I think Dan and I had talked on the phone and Vance and I had talked on the phone and separate conversations, but basically saying, hey, we need to shift this person 30 minutes and the contract allows for that. You don't have to meet. You're not modifying their hours. You're not changing their hours outside the scope of the contract. So that's, I think, part of our concern with this too. So, because the way you explained it the last time we met, that was different than our understanding of that language. And we feel that it made it clear the way you put it for your position, but obviously we didn't agree, so that's why we didn't include it here.
Right, is it, I mean, I'm worried in the way that I read it, that, it's 2:15, I'm supposed to get off at 2:30. Not my situation exactly, custodian, kid vomits, now custodian or supervisor says, hey, I need you to stay an extra half an hour today. That's really concerning to me, because for me, my schedule is super tight, and I know a lot of others do.
I don't necessarily think that's what we're talking about here. I mean, I would have a difficult time understanding our supervisors, no, you cannot leave. I get to add 30 minutes to you. I think this is what we're talking about here, because the whole thing starts about talking about the annual work week. So we're talking about something that is a general practice. And so let's say Brandon has an SNA.
They need to ride the bus home with a kid.
Yeah, so right now, they're a 7-hour-a-day employee, but because of this bus ride, they need to be 7.5 hours. And so based on this contract language, we can add 30 minutes to their day. And, granted, we're gonna hey, they may have childcare arrangements that may take them a day or two to, get sorted out. We're talking about the permanency of, okay, yeah, get that so you can get that childcare done by Monday. Okay, Monday, now you move to 7.5 hours. And that's their new schedule is 7.5 hours. So we're not.
What if it doesn't work for that person though? What if they take their own child home?
Well, we have the right to assign. I mean, I know that that's not awesome.
I think that's a problem for us.
And I think that's the
They
difference.
accepted a job that didn't do that.
Well, and I think that again, that what we've had is that minor adjustments of 30 minutes. Well, first of all, this is about the ability to assign, within however many hours they are, and and then other changes we've talked about being able to meet, having to meet with you for. So,
I mean, you see the difference, right? Like if you're saying, hey, this week we gotta roll you, you're gonna come in a half hour late, you're gonna, stay a half hour longer, or come in a half hour early, versus now we're just gonna change your schedule, right?
Well,
That's
so
really the rub, I think, here.
The two sections are, we've got the ability to increase or decrease hours by 30 minutes within those, what's listed as 1, 2, Roman numeral 1, 2, and 3, and then you have their work schedule. So, because if we're just shifting their start and end times, that's more of the B there that talks about their work schedules. Which our proposal was, if they didn't have a problem with it, we didn't have to, the employee says, yep, I can come in 30 minutes early, get off 30 minutes early, all better for me, they're good to go. If they say, nope, that does not work, then we have to have a discussion with the union. But we, as a matter of practice, we have adjusted people's schedules by 30 minutes within those employment status groups. So, I mean, that's not a new thing. I mean, I'm not saying it's happened often, but I think it happens in Brandon's world probably more than anybody.
And I think practically though too, I mean, yes, we have the right to assign, but I mean, that's part of that mutually agreeable piece that we had talked about last time. Like realistically, if there's a special program that has 6 SNA staff, I go to one person and say, hey, we have this need that's come up because of a revision or student, something new that has come up, right? Like if that person can't do it, I wouldn't say like, well, you're fired now. I would go to somebody else in that program and say, hey, let's work together. Is there another staff member within that program that can fulfill that job or shift their day? But the reality is though, if there's a need that comes up, like bus supervision, that's not going away. That kid needs that.
Right. Well, it sounds like we have some more work to do on those two. I think B, to be fair, I think B was probably a little closer than A for us, but.
Sure. So I'm just gonna look through, so we got a few dreams there to get.
Before we go beyond A, I guess, and I'm just talking off the top of my head here, not making any proposals, but if there was something in here about notification too, like if we have some time, a little bit better timetable, but if the advanced scenario comes up that way, we could, modify so people could have a chance to actually meet that challenge. That could, if that was an encounter to us, that could be something that we could look at. as trying to kind of get that closer, so.
Okay.
So you're saying like a set amount of forewarning or notice?
Yeah, like a minimum number. We could look at that proposal and we could work with that and see what we could figure out, and maybe we could get closer with that.
No less than X or something.
Some form of notice and, you know, okay.
Yeah, we have had people that were like, great, we'll start tomorrow. We've had others that say, you know what, I need a week or two. And perfect, great. So, but
If it
yeah.
happened to me, I wouldn't say yes or no without going home, talking to my wife, talking to my kids, and finding out if that works.
That's just because he wants a place to sleep at the end of the day.
Exactly.
Smart.
And that was, yeah, concerned about the yeah.
All right, so 13.
13. All right. So this part here under B, we want to reiterate what's going on there again, just to be really, really clear, because I think there was some confusion last time. When we say by seniority, if you have the 3 people that you're asking, and they, on paper, you could switch them in and out and just change the names, you wouldn't know. They have all the stuff you need. We want seniority to be the deciding factor there. Now, if one person has more of something than the other person, then they're not even, right? So that's the intent here. If this is not written in a way that makes that clear, we'd entertain a proposal from you that clears that up, but that is our intent for here and the video and everything, you know. That's the intent of what that language means for us. Because we just want them to get a little leg up because they've been with you longer and they've stayed here longer, right? That should count for something. So that's the intent of that first piece. The second piece here, the thing that I'm concerned about here with the employee shall be notified they're not selected, this seems like something that should be super easy because you have all that information, you're just not selected, you know. They have a process they can follow through if they want to know why. It doesn't literally have to be anything other than you weren't selected. But if I don't know, how do I know to access that process so I can get this, you know, work on the skills that I need when I'm trying to better myself to move up with the district, you know?
So you're talking about if we had 5 internal candidates apply for a position, the 2 that were not selected, and 2 were,
Just not selected, they didn't meet the qualifications or
Yeah.
whatever, yeah. So the last 3, if they're all carbon copies of each other for the most part, they all have the same experience, bring the same thing to the
but the
table.
2 deserve to be notified.
Yes. Well, technically, you would be notifying 4 of the 5, right, if there's only one job.
So, I mean, I think we're talking, so we have,
We do say. shall
upon
be
request,
furnished.
any district employee who was interviewed and not selected shall be furnished a written explanation.
Yeah, but so what triggers that is finding out that you weren't. How do you find out? Do you guys notify them?
We should, yeah.
They get a-
So that's the point of that language, so later on, we don't get somebody 2 months later going, hey, I was never notified, now I want to file a grievance. Because they didn't follow the language, they didn't, you
But
know.
is B asking or stating that in-district employees that are not notified for an interview, that they're notified why they weren't selected to be a part of it?
No, it's about the people that, I would imagine, I think what I was told, you guys interview everybody that applies, but maybe I'm wrong about that. Or if they meet the qualifications. This is talking about the sentence right before it, right? If you're notified, you know, your top 3 would be the seniority piece. The other piece would be, if you weren't selected, it could just be as simple as that, you know, all the candidates were, if they, upon request of you, say, I want to have a meeting, and sit down with whoever that does that meeting, they'd say, well, you know, apples were to apples here, and you had less seniority, so that person got the job, got the chance at the job. Or it might be, hey, you know what, Scott, you didn't have, you know, Excel, and that's part of this job, you know, so you didn't, now you know you go back and work on Excel so you can be prepared the next time the job comes up. The point is to make them aware, and if they choose to find out why, get the tools they can to make them more valuable for the district so they can succeed next time. That was, when we initially put this language in, that's what we talked about. The piece here is just having, I just noticed after we went through it, we didn't have a mechanism for making sure people know. And somebody brought up saying, well, I don't think I ever got notified by that. And this is a while back, and I think we went back and had them dig through and they did get notified. But it sparked a thing in my head saying, we better put something in there saying that we need to notify them. Or else somebody 2 months later will grieve and say, I was never notified, how can I request? That was the idea. Hopefully it's not overly cumbersome, but that was the idea of, you know, it seemed pretty simple for us, but.
The example we had was from the food service department that is applying for custodial.
Okay.
So under C, we struggled with this one because we felt like just letting us know wouldn't be, it'd just be clicking an extra email on there, letting the president or the union or whatever. We're really not understanding what are we worried about here? We really don't understand that one.
I think it's just more of a timing thing. I don't think it's really so maybe we can think about, within a certain time period or
Sure.
something. I don't think it's an issue of not wanting to notify. I just think it's, again.
It's one more thing to do, right?
Well, it's just, does Vance file a grievance because he found out before so-and-so found out about their, temporary position? It's more of a timing thing.
I would say in that story, I doubt it. I mean, we just want to know that they exist so we can
Yep.
track them, because if they're temporary for like a year, we want to know that. That should be a job, right?
Yeah.
I'm pretty transparent on that one. Then the next page, we made some changes here. So I think you guys were okay with the email, but we got to talking, we're just like, who the heck calls the district? Right? I mean, how does Kim prove that I called and talked to the secretary here and Vance sent you an email? It just seems easier to send an email so we have a record. So we altered that and crossed out call. And then also it's a district office. So is that a secretary or is that HR or is that Scott? Who are we talking about here, right? So we added that. We thought that just added clarity so we don't say, oh, I called him. I swear to God, I called him and talked to the secretary up there. I don't know why they didn't give you the message, right? It's like we're talking through that scenario. We thought that made it cleaner. I don't know if that's the right person, but I just put human resources, but having a person that they would talk to, I suspect you have one, right? That they're supposed to talk to if they want to do this. But if they email to that person, it seems like it's a lot cleaner process. Go ahead.
Oh, sorry, I'm sorry.
That's okay.
You don't want them the ability to call, because we suggested call or email. You don't want.
More and more we
do
thought
have
about it.
people-
So-
I'm
Yeah.
right with you on documentation. I'm all about the backup.
Right.
I think this is, I'm
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 all
for
about
this.
documentation.
Well, I'll wait till you caucus so you can
Yeah.
talk the rest of
But
it.
sorry, yeah. I
Well,
just
no,
wanna make
it's just,
sure. I wanna make
no,
sure.
you're right, you're right.
We do have a few people who,
Would rather call.
Would rather call, yeah.
But you know what? They all have access to computers, and how do I make the argument that Vance called, 5 minutes before you sent the email? I mean, how do I make that argument? And then Vance didn't get the job, right? I don't know how I make that argument. So that's the change there. Down below, I believe we accepted your language there. Made sense to us, and the intent was no more than 90 days, so we didn't think that was a bad thing. Down below, we decided to rework 3 for you here. So we put the existing language back in. Well, I didn't cross out C Article 3. I don't think it applies with the new language. It says, simply that they'll pay for it, but if you hire them, then you'll reimburse it. So if you have 10 people doing it and you only hire 1, you're not paying for 10 people. We thought that was a little fair because they're actually, now you're working for the district, so they could get reimbursed. That was the idea on that one. We thought that maybe would get us a little closer and not have you pay for everybody in the world out there. And I think that's it for that one, for us.
So reclassification, do we need to break it all? Is everybody doing okay? Or do we?
I think I'm okay.
I could use the restroom.
Oh,
Okay.
want a 5 minute?
So reclassification, so I guess walk me through.
Actually, I'm going to do this.
Okay.
So you said part of your concern was most everything was struck out, and then we, okay. And I understand that because that is a big change. Some of this is redundant because it was in the other proposal. So we're not opposed to putting back the pieces if they're not in there already that weren't struck out, that don't need to be struck out. They're listed below. It was put this way because it's very simple. It goes from point 1 to 2 and A to B, and it just really lays out a clear process. So I guess what I would ask is, can you please point to the parts where you want clarification? Because of all the ones we put out there, this one feels very hyper, like procedural, like very clear. So that's why I'd like to know what parts you want me to specifically speak to.
So I think if you compare current contract language 1 with your proposal, I would say that our current contract language is better because first of all, we're not establishing a committee unless there is a reclassification that comes forward.
Okay.
And then there's a time period that I think works, you know, in most cases. So I think that language is better. And then the committee comprising of the committee is, I think, what you've got proposed here. You know, you have, it's started at the beginning of the year, but may not be the best people for the particular, you know, particular situation. So, you know, take the one, you know, the easiest one that I always use is the one when someone gets pest management, and, you know, it's kind of, you know, Ron Vance, me, and Lauren get in the room and go, yep, looks good, you know, and, you know, that was the committee of 4 that took 4 minutes or less to solve it. But, you know, we've had, you know, office specialists or secretary ones, and we've brought in groups of people for those, and then, you know, we had one that, we just, I mean, they're specific to people that might have a general knowledge of it. So that's why I like our current contract language as far as your 3A or your proposal there.
So one-to-one is what we're talking about, it's 2 ones, right?
Yeah.
So I don't think that's unreasonable for one. I helped craft that language too. I don't think that that's bad language. This seemed a little more straightforward, but I would say that that's not going to stop us from reaching agreement on this article. The question I would have for you, though, and I think you made some good points when it comes to, you know, the beginning of the year versus, you know, make sure you have the right people there basically in the timetable. My question is, do you want any of the pieces under B? Does any of this make sense?
No, I mean, it doesn't make sense because again, in the current contract language, it talks about because an employee or supervisor believes the duty the employee is currently performing are more properly within a different existing job classification.
Okay.
And so you're talking, whereas your B says that if an employee feels that the alignment of their position on the salary schedule is not appropriate, but it doesn't talk about their duties the way, it just feels like it's more about, like, I deserve to be in a different place on the pay schedule where we're really, our current contract language is talking about their duties, and there's been drift or there's been more responsibilities.
And I would say that's the intent of the 1 through 4 down there, is to get at that. But I see your point. I mean, it's, again, that's not going to stand in the way of us getting an agreement on this article. It's good to have your input so we can craft things and make them, you know, look better to what you're thinking. So, okay, what other parts? I think I got that one down.
Can I interject
Yeah.
on A? The other piece would be, of course, you know, our concern on A is this committee, changing it to only being voting members instead of 3 union and 3 district.
Oh, I mean,
That's a significant
it
difference.
says below there, though. The voting members, this is 3 appointed by the district. I mean, it says
Right,
it
but
below.
they have to be voting members. They have to be actively paying dues, and they have to be classified.
No, that's not what that
No,
means
They're talking about voting
on the committee.
the committee, which
Yeah,
would be
right.
3 people.
I apologize.
It's all right.
Thank you. I
Sorry.
was reading it
It's all right.
as.
Dan doesn't like it anyway, so it's all good.
Well, it's the members' term, I think, is where I.
Yeah, members of the committee, sorry,
Thank you.
not
No,
bargaining unit
I
members,
appreciate
yeah.
that, thank you.
Like I said, I don't see 1 being a stumbling block. In fact, I
It's
think.
that, and that's where we want to be able to have these discussions, really, is go into this.
Sure.
You know, adding voting members of the committee or something, yeah. Thank you,
Right.
appreciate that.
Yep, no problem. And then what was your next example, Dan? Does C, you have a problem with C? We kind of say that.
No problem. It's already in there.
Yeah, it's kind of, yeah.
Yeah, so I don't have a problem with C. D, I don't have a problem with because I typically do that.
We don't really have E and how, you know, how do we, like right now, I think we,
Well, that's the thing, we don't have a committee, so
Yeah.
what happens now is I notify the person that, you know, yes, I received this. I oftentimes CC Vance on it, or at least tell them that I will be sharing this with Vance, or union president. And then we try to, at the next labor management meeting, we try to figure out, okay, who's going to be together. And I usually tell the employee that this will be brought before the next labor management meeting on such and such a date, and I'll update you on where it goes from there.
So I think what E is trying to do here is just establish a process for getting the information to everybody. I guess I'll ask Vance, do we feel that we need that process, or it can be slimmed way down to this, just saying the district will notify? Or,
I think the practice has been, or Dan has let me know, I don't know of any that happened.
Well,
But
yeah.
I suppose it's possible that it has.
Well, we have one, but Dan told us about it later. So,
So I'm not, using Dan as an example, I'm not worried about Dan not keeping me up to date, but I don't know who would replace Dan in the future, so.
And if it's those kind of
Sure.
technical things, I think that we're more open to adding some language within current contract language to, since we're having this discussion, we can maybe go through our current contract language and maybe make some adjustments to it to provide some of those more procedural aspects.
okay. What about F? Do you feel you need this?
So one of my concerns is it keeps talking about a new classification, and our existing reclassification is for an existing alternate position.
Mhm.
I am no longer doing Office Specialist 2, I'm now doing Office Specialist 3. So the new classification, the term, it would be in the existing proposed.
Yeah, I think the term new here means like, this is my classification, here's the one. Yeah. It's not that it's brand new
The
necessarily. Yeah. So that's, we can change that.
Wordsmithing on that.
Yeah, we can work with that. I kind of like that it has a process in here.
No, I think that process language we could take into, as far as like what the, hearing is. I mean, I think that sometimes people feel left out of the process, at times. So I think that we could look at adding a procedural piece there.
Okay. What do you guys do? Like G talks about closing the hearing. What do you guys do now?
Well, if
I know if you don't agree, it goes to the superintendent.
So we've really had all kinds. We've had the very easy one.
Yeah.
We had the complicated secretarial one that took kind of a whole process,
Right.
and we made sure that anybody that was going to be on that particular one, the people that brought the reclassification request forward, I think they got a retro, maybe.
There's a date at which it was received, and
Mhm.
Yeah.
That's usually
Had
how
it.
yeah.
Well, and a couple of these that have led, so like, take the campus security one that ended up leading to, it wasn't a reclassification, but we did create a new
Which you bargained a new position, yeah.
And then we did retro to
Mhm.
that. We've had one where we all agreed it wasn't a reclass, and that was a difficult
Mhm.
conversation to have. And then we had one that we disagreed, and then we both wrote proposals to Scott, and Scott made the decision. So
So you kind of have had them all.
we've had them all.
Yeah.
So
Is the timelines in here look succinct enough for you? I mean, is that too fast? Is that not fast enough? And it sounds like the process is very similar, but it's more of what happens at what time. So we had a great discussion about work days and calendar days, but how are these enough days in period, whether it's work or calendar?
So this part in G where it says that if the parties can't agree, then the matter shall be forwarded to the superintendent within 2 days of the committee's deadlock. Is that from Oregon City?
Yes, all this is for the most part. I trimmed some things out, or it's been even longer. They love their process up there.
I mean, I think we could figure out, what.
I just want to make sure, like it says, within 2 days. Is that
I'm
reasonable?
not sure if we're going to do 2, but I'm assuming that we can do 5 or less. So,
Yeah. Okay.
calendar. or
Yeah,
however
something like
we,
that.
Yeah, need to define work.
So
I just want to make sure that we're setting realistic, timelines so people aren't blowing past them or getting frustrated or, you know, getting weird grievances that we didn't follow the timeline, then we have to follow the timeline as the resolution of that grievance, you know?
And the classification committee is not on a locked timeline, correct? Because.
45 days, I think, in
you
your
have
language.
45 in there?
No, that's in
We
your
currently
language.
have that they will be brought up at the next labor management
Yeah.
meeting within 45 days.
Which one we're okay, I think we're okay with putting that back into the mix. Sometimes when you think you got a better process, you know, you just kind of try to put it all together and
No,
stuff you have is better.
You would not want to limit that committee too much, right?
Yeah.
Because there are times.
Sure.
that
Busy
5
schedules.
days wouldn't even have cut it.
Well, the secretary is an example of
Right,
that, right?
that's
Yeah,
exactly what
yeah.
I was thinking of. is-
But the 45 days, I believe, is when it has to be brought, right?
Right.
I think you're okay on that. I don't think we have a back end on that, except for
Perfect.
this part here, once a decision is made.
Perfect.
But I just want to make sure,
That's what I was
we're not
asking,
handing a bunch
sorry.
of things with 2 days to deal with when he's gone on vacation. You know, like, takes a day off, you know, so that's kind of the other side of that. That's why I was asking that question. Okay, so it sounds like G. So 2 is just really straightforward. I mean, this literally allow, if you have a complaint, Dan loves that word, you'll have a complaint, you bring it to this committee, and you still have to prove your case. You know, you still have to meet the requirements. I've seen 2 or 3 of these go through since this language has been put in about 3 different contracts, where they really were wronged. But I would say that's 2 or 3 out of like 100. That's not true. It's probably 2 or 3 out of about 30, you know, that come forward in the 3 different areas. And most of them, they start hearing themselves speak and where's your supporting document? Start to realize, okay, I'm upset for this thing for this long I've been ticked off about, and I really don't have anything other than a feeling, right? But they leave the meeting and they do feel better. I mean, I've talked to some of those folks, they've called me and they said, yeah, you know, I just realized it was really absurd. I just kind of got myself in this, you know, thinking that it was just this way until I had to really sit down and go, a process forced me to sit down and go through it. And then I realized, oh, wait a minute. Okay, I feel this way, but there's nothing supporting that. And then they've told me that they feel better, you know? And so I think that's valuable too, you know?
So I think, you know, I've kind of been mulling this one around a little bit because we don't have a process, we don't have a, you know, a system, we just respond to them on a case-by-case basis. So I've kind of sort of warmed up to this a little bit. I guess the thing about the as far as at least outlining, you know, your opening piece there about if an employee feels they've not been placed properly, then what do they do? I think, okay, maybe having that in there is not a bad idea. But I wouldn't see it going through that complete committee process because we have to evaluate these based on, you know, pay equity rules and things like that. Now, like in the most recent situation, you know, I don't want to be having these conversations without your involvement because I don't want to be accused of, you know, individual bargaining. So where it goes,
Direct dealing.
yes.
Yeah.
Where it goes in the process, I think I want to be transparent, but I wouldn't leave it up to a committee.
Well, the thing about it is that when your peers hear your argument, in addition to the management, you know, I mean, it gives extra validity and strength to that. That's why the suggestion is the committee, because if your peers are hearing this, maybe management just hates you in your mind, but if your peers hear it and they're saying, we don't understand this, you don't have a case here, you're not proving, you're not give us any supporting document. Equity wouldn't be an issue if they have supporting document to show, right? It takes some of that out of there. If they can't prove their case, then there's, you know, the panel would say, hey, you haven't proved your case, you know? You've had one of those too, so you know how that goes, right?
Well, I think the thing about it would be is that, you know, if this would open the door towards, you know, what, you know, sometimes people feel is comparable experience where we have to, you know, we can't have a committee determining what relevant experience is. And I think this would, you know, open that door towards, okay, I am unhappy about my placement, and then again, not being able, I mean, I'm pointing over there, they do a great job of trying to kind of go, what is comparable, and it is difficult, and you know, when people are bringing, you know, restaurant experience into food service, you know, like what similar, not identical. What's the one that we just hired recently was some, machinist.
Machinist experience.
So what does that look like, And then also sometimes people, trying to get them to put stuff on the resume and then, and that's another issue, which, they need to come and show us up front versus after the fact.
Right.
So,
Well, I don't think that the committee would be making that decision, right? Because you would, if they brought, let's use the food service when I worked for the Safeway Deli for 10 years before I came here to work for food service, right? So you should give me 10 years, in that path. Well, what were you doing for them? Were you serving food or were you back in the back of it cooking, right? Were you doing both? I think you have a process now that allows you to sort that out. So if they felt that that was wrong, they would come to this committee, they would restate their reasoning, you would restate yours, and at worst case scenario, would go to a deadlock to Scott, right? But I don't think that would happen because as long as you're applying, the district shows, just like they have to show that why they should get it, they show that they're applying the same standard to everybody. I'm not sure what the problem is there. They would lose that argument, right? Because the last thing we want, I agree with you on one point, the last thing we want is you were going to do this for, you were going to do that for, you were going to do this. That's going to get us in trouble quickly. And I don't think that would happen in this context, So it's up to you. I'll tell you this. I'll tell you, Dallas, Lincoln County. You writing this down? Oh wait, you got it on recording. Dallas, Lincoln County, and who's the third one? Well, Oregon City, but there's one other one I'm forgetting. They all have this language, and so far as I know, it's worked for them. So I'll leave you with some people you can call up and not just take my word for it.
all right, well, this one will be in our court regardless.
Actually, why don't you let us work on something with this now that I've got a better idea what you want, and then resubmit something to you. I can, if it's okay with the committee here, I can just email it to him if you're okay with that, and then you could look at it before our next session.
Well, so we've got just under 2 hours here. I'm not sure where we're going to be for time. Let's kind of reevaluate when we get to caucus and let's see if we can whip, we might be able to whip something up on this one. So let's reevaluate.
Okay. Because now that I have a better idea what you want, I think I can tailor it a little bit better.
So 16 and 17 are on hold until next time, right?
Yeah, we decided it makes sense to talk financials without all the financials. So.
All right, so then 18, our favorite topic.
All right, you ready for the districts? Since I know you love that. Dallas brought this to me, Lincoln County brought this to me, not this exact language, but similar language. Cascade has this already. I know there's a number of my coworkers that have language similar to this where it guarantees the pay time. Where we've added is really that on those snow days, you can have people work remotely, like doing their trainings, their videos, or different things like that, where possible. And Central, I think, has a similar language to this. So this is kind of keeping up with the Joneses almost. The point that we were making, I think your illustrious board member was making with most districts, I think this is the way this is going. Mainly because there's no budget hole created. If I'm a 180-day employee, you got the money from from the state to pay for 180 days, and if 2 of them are knocked out because of snow, you still have the money to pay for 180 days. Now, you may make me make those 2 days up at the end of the year, but those I work without getting paid because I got paid on the front end. So
let's, kind of like we did with reclass, let's just walk through this and let's just kind of learn. So you've got, so in 1B, you basically just outline that the employee shall have unlimited emergency closure days. So snowpocalypse comes, there's an unlimited number of emergency closure days. So is that what that's trying to say there?
Yeah, there's no limit.
So classified shall be paid their normal wages and shall not be required to report except as provided in this article. So somewhere we're going to deal with that going down. Okay, the district may choose to make up emergency closure days. If it does, these days will be made up without pay with, shouldn't see, the below exception.
Damn it. All right.
So the district shall identify those employees required to work on a closure day. Those employees shall be paid the rate of 1.5 their normal rate of pay in addition to and paid days the rest of the employees get for all hours worked and shall be paid on any makeup day, if any. Only employees required by an administrative supervisory employee to work on a closure day will be paid at the increased rate. So where'd you get that from?
Boy, this language is, there's language all over the place on this. Some places pay double pay. I think actually you do for the first day, right? And then
For day one, yeah.
Yeah, and then most places they'll do time and a half. That's what they do.
On top of the closure pay. So 2.5 times is what you're saying.
No.
Okay, that's what we're
That would be
looking for.
super easy if that was it. No, some do it that way. Some do it, you get time and a half for the day, and then if you, for the whole day, even if you don't work the whole day. And then some do it, you get time and a half for the time you work, and then let's say you don't work the last 3 hours, you get straight pay. So it really is all over the board in
Okay.
all these different groups. I'm trying to get it to similarity, but that's a process, so as you see. So that's the intent, is that it would be time and a half. Let me look at this language, because I got 5 contracts right now, make sure I'm saying it right. I got
2.5 times the rate of pay.
that's what it currently says.
Right,
Yeah.
no, and I just
Yeah.
want to make sure
Yeah.
we're talking the same thing.
I mean, we're bargaining here, so I can understand if you
No,
don't come
that's
back
okay. I just-
exactly with that. No, I do that for Dan's
To
purposes.
clarify any questions,
Yeah.
Yeah.
In C, are we referring to people who are expected to show up to a site, or are we talking about people?
Ah, great
Yes.
question, great
Yes.
question. People are supposed to show up to a site,
Okay.
Required to
Yeah.
report.
because that's
to
the
a-
added danger of them coming in those days.
Yep.
Yep,
Okay.
good question.
Great,
We could make that clear.
okay.
On D, which is current contract language, would you be open to, unless mutually agreed upon by the employee, the district, and the union?
I think we'd entertain a proposal from you on
Okay.
that.
Well, we had a couple situations here where, because we were offering remote work,
People took it.
well, no, I mean, some people said, I've got an appointment,
Yeah.
I've got a doctor appointment, I'm calling in sick today.
Mm-hmm.
And so it was, what they would like to do is, I'd like to use my sick day today, because I don't
Right.
want to have to make up these hours, because you offered me remote work. So this language was built when we didn't do that.
Right.
And so, and in most cases, if someone snowed in, they had used a personal day to go on a little vacation, they're gonna want that personal day back.
Mhm.
So,
No, I think we could look at that. I mean, that makes sense to me. We'd have to talk about it as a group, of course, but it does make sense why you'd want that.
so then in E, so as stated in this article, the district may choose to make up emergency closures except for the first 3 days of emergency closures each school year, so we're going from 1 to 3?
Well, this proposal is. We'd probably be open to having a discussion about that.
And then, however, classified employees in no case shall make up more days than the teachers make up.
You're on.
We've heard it just about every year, teachers are making it up on holidays if they're already working, or not holidays, but.
No contact.
Conference days, right? Well, they're already working that day, they're not really making up another day, but now I have to make up that day.
I heard a lot of this in both my ears and in my dreams, unfortunately, of going to his union meetings. Yeah, this is something it's a thing. I'll just put it that
And you're
way.
referring to a teacher's in-service day becomes a student
Contact day.
Okay, I just wanted, yep,
Exactly.
just clarifying.
So for the 10 and 11, for
Right.
10-month employees that had 2 days, the 2 non-contract days, so like conferences.
Right,
So, okay.
yeah, just making sure.
Yeah, I still hear it echoing in my head.
It's like their 3-day week.
I guess so.
The district shall have the right to require employees to work remotely, so basically what you're saying there is for those 3 closure days, we could direct them to work remotely.
No, I think it says
Oh, for all
beyond,
employees beyond, so it's beyond
Right.
the first 3, okay.
or whatever that number becomes. Yeah. I mean, I suppose there could be an option to, well, we'd have to have that discussion. Yeah, I should just stop
Well,
there.
I have to work on a day because I have to make sure my subs know
Right.
that they aren't coming in. I
Right.
called every single one
Right.
because I don't want them showing up.
Yeah.
And so for me, that's not an option to not work on
Right.
my day at least.
Well, that's where the 2.5
You can
times
take
come
that
in.
chair and one of those chairs, yeah.
And that would be a question we would have is for those staff who do not report, so they don't get the 2.5 times pay, but they work, how do we handle it? Everybody has different work calendars. That's kind of what we've been struggling with. We do want to solve, for sure, but Lisa's a perfect example. 4 hours of her day is 12 months, 4 hours of her day is 10 months. She is very special. She knows how we get to, so 4 hours of her day is under the 12-month clause, and 4 hours a day is under a 10-month clause, so there's no makeup day for the 12-hour day left, but there's makeup day for the 4-hour, or the, sorry,
Potentially,
you're
yeah.
tracking me.
Yeah, I follow what you're saying.
Yeah, so that's what we've struggled with a little bit, is our 12-month employees, that there is no day to make up.
Mhm. And I've seen in what we've put in other areas, like Central being when we just added some of this in here, is that the videos and stuff that you see at the bottom down here. Going back to your other question about what about people that don't report but can work from home, essentially remote? I've seen that done one of two ways. I've seen it done that it's a straight time, normal. They just pay them for the whole shift instead of the 4 hours, let's say, of the 8 hours they work. Or they pay them, like in your example where they have you have at least one closure day on your current contract, they pay them for that, and they pay them straight time for the hours that they actually work. So basically let's say it's 4 hours, they get double time for 4 hours, but then straight time. Like I said, it's really all over the board.
Right.
So,
and that's what we're asking for, is if
Yeah.
you can help us look at other similarly
So you
situated
say
districts.
Central
School districts.
Central, Dallas, Lincoln County,
Yeah.
Oregon City. I know there's others. In fact, I think North Santiam is one of them.
So we will look,
That doesn't have I take that back, North Santiam does not have unlimited yet, but it has, they're bargaining right now, but it has language about the 2.5 times and the 1.5 times and all that kind of stuff in their current contract.
And one other, I guess, question I've had due to our unique district structure, school by school issues has become a very difficult thing to deal with. So we're talking about, district may choose to make up emergency closures. You're
Yeah, what
saying
about
that.
like people at Silvercrest that don't work because of their weather yet?
Right.
People.
Well,
in town have to
the
work.
language would apply. I mean, it's language for the whole district. So if you have Silvercrest miss 5 days, you only miss one down here, then assuming with current language, they wouldn't have to make it up, but they'd have to make up 4 potentially, right? I mean, that seems, you can't, I don't know how to do that without going
That's-
crazy, Yeah.
Yeah.
And you will have such people at higher elevations, you've already seen it, I'm sure, yeah.
We have, and we were
Yeah.
hoping maybe for some additional thoughts on how to.
Well, we'd entertain a proposal from you that addresses that.
We've really dug into that one, and
Yeah.
we have a very unique situation
Yeah.
here. And unfortunately, certain years are pretty smooth and fairly easy to resolve, and then other years are a little lopsided.
Yeah.
And you're right, it doesn't, it's an issue we'd love to resolve, so. we're open to it.
Well, the first 3 days would take care of a lot of that, right? No, I'm just kidding. Sorry, Dan, couldn't resist. But yeah, I think that's one of those that we probably could, we're gonna have to both take a stab at it, quite really, and trying to figure it out, so. Because it's just not as simple as, everybody does do it a little differently, so it is hard to even get an industry standard, if you will. It's even hard for that, because everybody does do it a little differently. Some are similar and some do it, like I said, half days and full days and double time, 2.5 times, straight time, rate time. It's all over the place, so.
all right. Well, that was a good discussion. We can, that one will be
Yep.
back in our court now. So,
Okay.
I think it's finally our turn.
All right, you guys got here just in time. Get the professionals. Which article are we on, Dan?
So 19, sick leave.
Oh, wait, wrong packet, that's why. All right.
So most of this is what you've seen before. We caught, a couple of the grammar ones, so where you see there's an okay there, it was just something that we had initiated from your grammar proposals.
Okay.
Under F, where it says sick leave is to be used in accordance, a lot of this is just moving some things around to hopefully be easier to read. And then again, strikeouts of things that we haven't been practicing, which I think you're mostly in agreement with.
So you have
I-
two struck out, and you have okay. These ones struck out below, and you put okay.
So,
These are the stuff that we struck, correct?
so when we put an okay, we're indicating, so like on A, you changed to make
Right.
sure that there was 12. We're just saying, yep, we're okay with
Yeah,
that.
yeah,
And so I get you now.
yeah.
In your proposal, you had also struck those out.
That's what I was double checking.
So we're agreeing with those strikeouts.
Okay, thank you.
Yes. So on your last proposal where the employee at the discretion of the district may at the discretion of the district be required to furnish a reason issued by a licensed physician or other satisfactory evidence of illness extending beyond 5 consecutive workdays. Your proposal had
They get notified before they come back, right?
yeah, so just was curious about that.
So, I don't recall if I've seen it here. If it was real early when I first came here, but I have seen in other areas where I show up for work after 5 days, say, now I need a doctor's note. It's like, well, I'm better now, or, that's they have to go back to the doctor and schedule another appointment. We're trying to skip all that piece, just have the district say, bring a note when you come back, so that when they see the doctor, they can get that note before they come back and not have to make a second, and pay a second copay and do all that stuff. That's the intent. If you have a better way of writing
Got
it,
it.
we'd be open to that, but that's the intent of it.
Yeah, our worry was just that that might keep the employee out longer than the 5
Right.
days while it's waiting to try to get into.
Right.
We just might have a reason why we need the documentation. They might be eligible for FEMLA. There's just, there may be a reason why we need to ask for the documentation. We certainly don't want to send them back out of work to go get that
Right.
to whatever degree.
And
So-
we don't have a problem with you guys requesting the documentation. It's just that we want to make sure that they know before they come back. That's all.
So
Yeah.
as long, like taking out the request for, if it just says, this note shall be provided prior to the return, is what you're asking for.
Yeah. Yeah. Well, you guys don't always need it though. That's why I think the request is in there. Because sometimes they're out for 5 days for something specific. It's not a FEMLA thing, or it's up to you. I'm just saying that's why I put it the way I did, because you still would request it. That way you wouldn't have to do it every time. That was the idea. So, but if you have a better way of writing it, I'm open to
Okay.
looking
For
at it.
consistency, we always request.
Anything past 5
We aren't gonna
days
pick and
is a
choose,
request.
no.
Yeah.
It is,
Okay.
it is practice, yeah.
Then I guess we'll see that counter. I think that's fine. I mean,
Okay.
that's not our rub. Our rub is that we get it
Okay.
done before we come back.
Right, exactly, no, I
Right,
appreciate that.
right.
Okay. So I'm not sure if you have any other questions on, before we get to our sick leave bank proposal.
No, I think this one, there was quite a few things in here that looked pretty, but let me take one more look at one more thing here.
I did have a follow-up question from the 31st. You told us that there was some language in 1B that you did not believe was legal. Did you get clarification on that?
1B, hold on a sec.
Where the front-loaded sick leave is prorated upon exit, that...
Oh, I haven't heard back on that actually. Yeah,
Okay,
that's just,
if you could find out,
no, it's,
I know a lot of our peer
Yeah.
districts are in the very same boat.
Yeah, yeah.
And so if that is a law
Yeah.
now, or something that has changed, we
Yeah,
probably want to
the official
be
answer is,
compliant.
I don't know.
Thank you. I just wanted to follow up.
We have 2 people that deal with that, and one's out of medical leave. They have a note. And then the other one is just super racked with what's going on right now with the stuff on the state of the politics of the Hill. So I did leave that message, but I will try to follow up again. The concern is that, I think the law says that they get the 2 weeks, and then I don't know that it leaves room for proration, but I'm not an attorney, so I'm waiting for that. But I'll make another note here to follow up, because I did make that request.
So the sick leave bank counter proposal is almost identical to what was agreed upon with SFEA, and so looks like the district is moving away from, you know, the traditional sick leave bank that would go to the board. And I think the board is comfortable getting out of the business of approving those, so I think there's some mutual interest here. And so for consistency's sake, we would like to have it, the implementation of basically more union-controlled sick leave bank to look similar, so that we're not having two sets of systems to try to work with here.
Yeah.
So I don't need to necessarily read the definition piece of it, but
No.
just hit the highlights. So it's a committee, you will pick 3 people, and then I will serve on that to just oversee it. So I think that helps protect you guys as much as anything. And then it talks about how people, they donate to be a member of the sick leave bank.
And yours, is it compulsory or do they get a choice?
They get
They get a choice, okay.
So you only get access to the sick leave bank as if you donate.
Yeah, no, I'm just,
Yep.
yeah, okay.
I think it is important to note in 4B that you are not eligible for the sick leave bank if you are receiving funds from paid leave Oregon.
Of course, yep.
So, and then it talks about the minimum number of hours there,
Where did you come up with that 400?
SFEA.
License.
So, okay. So if it falls below that, then they'll ask for additional contributions, yeah, okay, I understand.
So, and that's 50 days, I think, something like that. Yeah, so,
Is it 50 days?
and so if a classified employee is already a member of the bank but does not have sick leave available to donate at the time of the contribution, they may remain a member of the bank and the donation will be deducted at their next. So if someone's, you know, if C takes effect,
Oh, I see.
somebody isn't kicked out, they'll just donate when they get their day.
Is the 50 days spelled out somewhere in here?
It's 400 hours.
400 hours.
Is
Oh.
divided by 8.
Yeah.
We're just giving you a ballpark.
But that's, oh, okay, how many days can they request though?
That's.
I think that really is up to the committee.
Oh, yeah,
Oh.
we don't wanna.
Wow, okay. All
And I
right.
mean, if we want to spell out more of that, you know, what I typically do when I meet with people on it is try to determine, you know, what I explain is it's not long-term disability. It's how do we get you from point A to kind of point B? Is it, you know, until you get back to work, is until, you know, you're covered by another program or something like that. So that's why sometimes it's been 10 days and we've had some that have been, well, frankly, up to 50 days. We've had,
We did a 175.
we did have one that was 75.
Yeah, usually it's between like, the lowest I've seen is 15 and the highest I've seen is 60 days, so. That's why I was curious, that's why I was asking, so.
Well, we had, I think they were both classified too this year, that the board authorized 25 days, but the employee got like 70 donated. So, so what we did is we went back to the board to get another authorization for another 25 days, but we didn't go out to the employees and ask them to donate to those, because we already had the days donated, so.
Well, I don't want the board to feel bad. You can do what they did in Roseburg, and they get the sick leave bank, and if they still need it, then the board could do their thing too. No? No to that?
So,
So they did in Roseburg. All right. Okay, well, I understand that proposal. We'll need some time to obviously dig through it and caucus.
all right, so then the next one is also ours, training. So, we changed some language in 3, which is what we were talking about earlier when we talked about how we talked about kids. And so, I don't know, Brandon, do you want to read that just to kind of talk a little bit about trying to broaden this language? So we hope that you're in support of this.
Yeah, is this on our?
So if you, son number 3.
Yeah, so we took a look at this one, and instead of having it say particularly challenging special ed students, just thinking about students that have really comprehensive plans of support, because I think, that can look really different for different students and frankly for different adults. I mean, people have different comfort levels with different types of support. And so I think this just is maybe a little bit better way to phrase it. Looking at this, what is the adult investment? What is the adult time for that plan of support for students? But I don't think it necessarily changes the intent of 3, but maybe just phrase it a little bit differently.
And then we also removed the quotations around necessary, because I'm not sure why they were needed to be there. It's like someone should be able to ask for the necessary information to be shared. So we just deleted those quotations. So
So the legal requirements around competition, so I think that will fit with the bill that just got passed on that subject too. I think the way I'll have to think about it, but I think that'll work, because that's a legal requirement, so I think we're okay.
So then in the tuition reimbursement section, we added a sentence because we've also added a small section. So under 5, there is a sentence that funds for tuition, professional development, or licensing and testing fees, which we'll talk about in a minute, must be approved in advance, which we have forms for. So the previous language around tuition reimbursement hasn't changed. Your proposal had a portion in there that mentioned licensing and testing, and so we just added a sentence, or there's another, so you've got tuition, you've got professional development, and you've got license. Now we're adding a third one called licensing and testing fees. And so we just added a sentence there, and that they could be reimbursed upon successful completion of a program or assessment up to $350.
So I guess the question I would ask is, has this fund any year, that the last 3 years that it's been there, been fully depleted?
No.
So I think one of the things that we'd have a concern about, and it may not be, those funds go back to the district while they roll forward to the next year to help fund. So 10,000 this year, 10,000 this year, 5,000 roll over, and then you put another 5,000 to keep it. Essentially, that's how it works, right? So our concern here, I'll just say off the top here, is we're kind of going backwards on the funding level. Like, with the cost of, inflation and whatnot. I mean, we were topped out, I think, at 14.5. Now we go back to 10, and we work going back. I'm just curious why that came from.
I thought you might ask about that. Honestly, as we're looking at the pie, if you will, of just, with your, we consider this part of our financial proposal as far as where that goes. And so the reduction was simply the fact that people haven't accessed it. And so trying to say, well, let's save a little bit here so that it's part of the overall financial. So, we have obviously if people take advantage of the 4 credit hours and stuff like that, that 10,000 could get depleted pretty quickly.
Sure.
So, which I think that we would be, I guess it is on camera so people are here, is, we would be open to, if it got depleted, especially 2 years in a row, I think we would be open to an MOU or some other kind of agreement to try to, our intent is not to reduce the amount.
Well, we have language in B that covers that, but, okay, so I'm just trying to understand, because if that's the case, then it might make sense for us to say that those funds stay within that pot, and they're added to, just because it would, if any benefit they didn't use this year would be there next year, because before the benefit would kick back to the district to backfill or whatever they want to do with that money. Just trying to think out loud here. This might be something that we might suggest, because it would make more sense with that smaller amount, that we are saving our acorns for the winter in case this year it's slow, next year it's real busy, right? We'd have a little extra for that year. And it would be based on a true cost versus, a cost that could fluctuate for savings for the district, but it would lock it in, so we'd have it saved in that. And I guess we get to the other side of your argument, where now we got 3 years and we got all this money in there. We might have to have another discussion about what we do with that money or how we use it if it's not being utilized.
So, if I understand what you're asking, so let's say the first year you use $5,000, and so then the next year, there'd be $15,000 in it? Because it doesn't increase unless it's exhausted.
Yeah,
Unspent balance rolls forward is what you're.
Unspent balance rolls forward, so
Yes.
then the next year you'd have 15,000. Let's say all of it was used, then we would probably go to the $14,000
Yeah.
amount.
Right.
Okay.
So it would be technically a reduction in year 3. If you only spend 5 in year 1, you have 15 in year 2, you spend all 15, so year 3 drops to 14 or 12 or whatever
So-
the number is.
but that's not what I was saying, but
Oh.
I do appreciate that, looking at it from that direction. I was simply saying they stack. That's as simple as that. It would go up 12 regard, I see it says exhausted here, but that's not what I was saying. I was saying it's 10 this year, you use 5, it'd be 17 the following year. And then, I know what yours says, your language, I'm talking about a possible counter. And then, of course, if you get to the end of the road here, and we have a bunch of money left, then probably what we need to do is reassess, but at that point, but, okay. But that is an interesting take on it too. Not exactly what I was saying, but,
As Dan was saying, from the financial perspective, it's just part of the pie. So if,
Yeah.
do something like that, then the wages need to come back. So when an entire PD pot is not spent in full for the classified, now we have greater movement for wage adjustments and those sort of things, so.
no, that's what I meant. That's what, I
Yeah.
understand. No, I understand. That's what I'm saying is that if we're gonna factor this into a financial proposal saying, we're assuming we're gonna spend 10, but we only spend 5, that's where it would get weird, unless we say we're gonna spend 10, right? So that's essentially what I'm saying, but a lot of good ideas here, something for us to talk about in caucus for sure. Please go on. I didn't
And
mean to
just
run
one last thing is
Yeah.
just to say that the annual report, we did change the date from July 1st to August 31, and that was done for a couple of reasons. One is, ending the fiscal year on June, I mean, it's a busy time for them to be producing another report. It might also be with the tuition, there might be have more people that are taking summer courses, and so so there might be more use of it during the summer months. So we just changed it to August 31st.
A quick question, back up to C. Do we have 450 for everybody else and 350 for licensing? Or did we not change that 450 to 350 in B?
We did
So
have it.
B is still 450 for professional development. Those are workshops, things
Sure.
like that.
No, I'm just making sure I understand what you proposed here.
And the
Okay.
only reason I picked $350 is because I knew that people that have been getting the emergency licenses, it's around $300, so I just kind of picked that number. So that number is open for.
Okay. Well, let's say if you want Daniel to get some additional computer stuff, that could be $1,000, for his certification to test on that. So that's why I was questioning the difference in the cost. That's the only reason why. And my brother lives in that world, so I kind of know some of those fees, what they cost, so.
Okay.
All right, perfect. I think we understand that one too.
All right, so now we are
To 23, right?
23.
So, 23, I thought this might be a workaround. I just struck this because we have a discipline article, but you guys had expressed an interest. You wanted to be clear that some of these things could fall under discipline. So what I did here was get rid of the mention. I don't know why it specifically mentions discharge, not suspension, not warning letter, just discharge. So we crossed that out. I just said we in accordance with Article 9. Wherever we land on that article, we just follow the same process. I mean, it seems fairly simple. And I really don't know why it just says including discharge instead of listing other things. I mean, because it could be a warning letter, it could be, and it also seems to be getting the cart ahead of the horse because whatever they did will fall into one of those spots in Article 9, whether it's a warning letter, based on their behavior. So that's our back to you. Not a whole lot there, but hopefully it makes it simple. I know we've done that in a couple other chapters, just referred it back. Me and Nancy have, so I don't know. I don't remember which ones off the top of my head. I want to say Oregon City was one of them. I can't remember the other. I know there's two, and I can't remember the other. It might have been Roseburg. I can't remember the other one. But that's pretty straightforward for us in 23. All right, 25. So it looks like we're all agreeing that we can use the number 4 instead of the word 4 down below there. So that's highlighted in green. The next page, So B here, I mean, I guess I'm unclear on this one, what
Can I
the
ask a
objective
question
is.
on 1A? So current contract language says seniority shall mean a classified employee's total length of continuous service, including summer recess periods, since their most recent date of hire, and you're changing that from since to from.
I think it's the same difference. I'm sure it popped up for some program for somebody, so this is the grammatically better. We can leave since, I don't care. Would you like to leave since in there?
Yes.
All right, easy enough. All right,
All right, so then we're on to,
we're on to B on the top of the next page.
okay.
Now, what we're trying to do here is say, hey, look, if you're pulling a pension and you're working back, you're getting paid twice, and you have to be laid off before any of our people that are just working and getting one salary. That's what we mean this to say. So I'm trying to figure out what the pushback against this is. Or if it's not, maybe I didn't explain it clearly the last time, I don't know. I tend to do that sometimes.
Well, so I think the thing, when someone retires and starts working back, they start over with seniority and probation. So, I mean, they would be in the same, I guess the thing about it would be I mean, most likely, depending on when this would go in, I mean, if in the event that we had a layoff and recall process, I mean, most likely they would be a probationary employee with lower seniority. But if we had someone take advantage of that and start, but we don't go into this for 4 years from now, I mean, would they, even though they have 4 years of experience, disregard possibly 20 before that, if they had 4 years of experience, why would they be the first person to go if, just because they're a retiree? I mean, they've worked 4 years back.
So I think it boils down to initial fundamental fairness. If I'm already receiving a check, and now I'm working back to get a second check, and Vance over here has one check to feed his family, why are we laying Vance off when I'm the least impacted financially by that? Do you see what I'm saying? I think that's really what it is. But the process you laid out, I don't know where that's in the contract, where it says that they start over their seniority. I don't think we have that in this contract, do we?
Well, it's just, no, I mean, it's not the contract, it's just
Okay.
that when someone comes and says, I want to retire and work back, we walk through, this is how this works. You retain pay equity rules say that we have to pay you the same years of experience. But it is considered a break in service, and so you are, go through the probationary process and those sorts of things. So,
Well,
I still don't know if we've had anybody.
Yeah, right.
We do have food service.
Oh,
So, well, we knew it was coming eventually. I guess if we had a process that laid that out, our team could look at that. But right now, we don't have a process for people working back. I mean, we decided not to do it because we didn't have anybody, and we said we kick it down the road. Well, we're down the road now. So,
that's true, we do have a food service employee.
So, I mean, if we can figure out the process, and even if it's the one you laid out, at least that's something we could look at to see if that works for folks. But we just don't have what we feel is a process on our side. Because that was a change with the PERS part that we decided to table until it became an issue. So I think we're
Well, we're in
there.
open bargaining now, so you could make a proposal.
It's right here. But I'm happy if you want to come back with something that, that actually speaks, if you really want that process and speaks to that process. I think we'd be open to looking at that. We just don't have anything right now. So.
And can you, just to understand, I see what you're saying. I mean, I have a backup revenue stream, right? Or income stream. One question I have, because I'm aware of this, working back after retiring from what? We have a lot of people who have pension from either non-school district or non-PERS even. And
Yeah.
so now we have
Right.
to ask people if you have a Boeing pension coming in?
If they, I mean, I'll say, I know we're going outside the school district
I'm
now,
just
which I
asking.
know you didn't want to do earlier, but no, I'm just kidding.
But this is I'm clarifying your language, so
Yeah,
we
yeah.
will have
Specific
a
to
fire-
PERS.
Okay,
Yeah.
so the firefighter that is gonna be working for us next year would be laid off.
Technically, Technically, yeah, the way this is written, they would.
The way the
Yeah,
Senate Bill
yeah.
1049 is written, he's, yeah.
Yeah, technically,
Okay, I
that's
just wanna-
correct. However, there is at least one district, I think, that employed what you wanted. They said, hey, it's a break in service, they start over, you know, we don't cancel their membership, we keep the same rate, they have a list of things that they have to do. They did want that, and that was agreed to. Can't remember if it was Dallas, but I think it was Dallas, but I can't remember. But that's not unheard of. That happens in other places. There just has to be some process that people can point to and see. I think if we're comparing apples to apples, like Dan's doing with the 4 years here versus the person with 3 years here, I think we could have that discussion and feel confident when we got to the other side of it that people would understand why, versus the person who just comes back and then gets these 2 salaries and we don't have any process and they feel like, why am I being like kicked to the street, right? So I think we could have that
I mean,
discussion.
I think because I think that most people are going to be on the lower end of the seniority thing, but I do think that if somebody's worked back at 4 years, I think that seniority is a little bit more of a consistent piece. I know that's going to come back. You're going to use
That's all right. I love hearing it.
So,
No, what I'm saying is that we would, if you want to set some process like that forward instead of this, we would be willing to look at that. Honestly, we just really want to have a process that we can all talk about and get behind, so that we're all saying the same thing. Because I think that, what about the person that's been here a year and a half? Forget 4 years. The 20 years, they come back a year and a half, and now they're doing layoffs, and there's somebody who's been here a year, right? We're going to have, it doesn't matter the timetable, we're going to have somebody who's affected by this, and without a process that they can point to and say, this is why we're doing this, I think it makes it problematic. Although I will say, a lot of those private sector pensions are getting really, really tough on reemployment rules, man, let me tell you. Oof. All right. So that's there. Oh, did you want to keep going through?
no, go ahead. Keep going.
So 3, this feels innocuous to us. I know you said you're worried about adding days, but it feels like 2 weeks is not really crazy amount of time to ask for somebody to change their life or whatever may be happening, to get things situated, to see if they can even do it. Like, can I even? I have this chance to bump, but can I even do it? I got to talk to the wife, see if we can shift the schedule, or the husband, or whatever it might be. How that extra 3 days doesn't seem like that big a deal. Usually these things well in advance. I'm sure there's probably some example somewhere where it came down on you the next day, but usually you get your funding when it gets whacked, we know in advance, and we try to fight it and all those different things that both our groups do. But it feels like 2 weeks is just not that much time to, it doesn't feel like an unreasonable amount of time to be able to make this decision. So we just left 10 in there. We just felt that's pretty standard, and quite a few of the neighbors have that too, that language in there too, the 10 days. Let's see here. Down below, we came off of 3 for the bumps to 4. I think we were at 5, and 3 was the original, we came down to 4. So that's a change there. Because when we went through and did the math, we figured that 5 would probably be ideal in some areas, but it would probably be overkill in others, so we felt like 4 might be the middle ground.
And to clarify, that would be then an 8-week bumping process.
Potentially, I didn't look at the total time, sorry.
If you have 2 weeks
Yes.
for the first bump,
Yes.
we
but-
have a layoff process of 8 weeks where people are waiting for their notice.
Yeah.
It could be that.
Yeah.
It could be though.
Could be, exactly. I understand sometimes there's
Instead of
not
like, what, 6.5 or 6 3/4 week or whatever it is. You're right, it could be that. The next page here, it looked very familiar under hours, reduction in hours. We're trying to talk about the 5 versus 6, or the 6 versus 7, the 5. So that piece we've kind of gone over a couple times, but essentially this whole page is basically dealing with that issue, with the law and all that stuff, and some of our folks interested in that. So I'm not sure it helps to talk about that again, but we can if you want. The next page I think is much more interesting. So this here under E, I feel like we've been down this road, Dan, a few times before, at least the last 2 bargaining. So you guys are currently at 120. I think originally you were at 130 or 40 or something like that. Really, we're at 30. Some districts like Lincoln County, it's if you're hired the day before July 1st, you get the bump next year. But I would say most of them kind of float between about 30-ish to like 60, a few that are 90. Really what we're trying to do is give these people incentives to come back. That's really the intent from us here, is if they work a period of time before that, the school year's out, we want them to say, oh, I'm gonna get a raise if I come back next year. So incentive, that's really the intent of this language here. Wait a second, make sure I got this right. Yeah, that's the right thing.
Yeah. If they're
Yeah.
not looking for a job during the summer, are they looking for, a job that pays higher than what they're making now? Probably, right? So they want to look forward to that raise coming back here.
We're just trying to dangle that carrot for you guys to help them come back, and say, oh, I know I'm gonna get this raise if I come back.
The sentence before that says the employee shall be placed on the salary step on which they were placed prior to the reduction.
Right.
One step movement shall be granted if the employee was employed a minimum of current contract language, of
Right.
120 days at
Yep.
the time. So if they'd worked 120 days into a school year,
Currently, that's how it would work, yeah. And we're trying to shorten that number. I mean, we just want, if people come in towards the end of the school year, maybe 30 is not the right number. Like I said, it floats from about 30 to about 90, somewhere in there. We're just trying to shorten that period because we want them, if they come work here and they we want them to come back. So we want to have that carrot to bring them back,
Again, this is just instances of RICs. This is all this, yeah.
Yeah, correct. Because what happens if they find another job and they go, well, I can make a little bit more here, but what if I come back, I know I'm going to get this. Well, maybe I'll come back, right? Fingers crossed.
So just one thing on your grammar thing, you've got, this may again be working from a different
The previous
document.
version,
Our language says period of time the employee was on the reduction,
Yeah.
so just letting you know.
Okay, I'll make a note on that. Again, we can go with that. I mean, the grammar is just
Yeah, I just
nice, but
noticed
it's
it.
not necessary. No, I appreciate you pointing that out.
I think we don't have English teachers.
Well, we had a weird server issue. Our server died, so we got some weird mergers going along. But my favorite one was in North San Diego where we merged sick bank and sick pool. Boy, when I tried to present that proposal, so then undo that, I had to pull it off my actual computer here because it was that. But they claim they have that worked out now. All right, I think that concludes for us.
So
Did you have one more?
why are we wanting to extend the number of days that an employee has to notify the district to come back from 7 to 10 days?
Because the process is you send them a certified mail letter, right? Is that essentially, or call them, or maybe both. As far as I know, I'm laid off. This is the real world example that happened in another area. My ailing parent, we go back, the family goes back because I'm laid off. I'm the sole breadwinner. 2 weeks we're taking care of this person because we think we're laid off, and then, we get the certified mail while we're gone, and we come back and it's like, wait a minute, I was only gone for like a week, without the weekend, but they missed their timeline and they lost their job, That's essentially it. Again, 2 weeks feels like a reasonable amount of time for people to, oh wait, you need me back, as long as they know they have that 2 weeks. If they go out and take care of Nana or whatever, they can come back and, in time to be able to, while they're getting that set up, come back or they're gone on vacation. Maybe they're a person who can do that when they don't have a job. I don't know. But that 2 weeks makes it really clear you have 2 weeks, and that's it. Not 7 days. So if it's hit on a Wednesday, then that's a Friday, or however that's going to work. Just trying to kind of like your calendar days and work days. We're just trying to streamline it there. Make it all the same.
So then the next one is the term of the agreement, and then we just sent that to you. So we want a 3-year agreement.
Understood.
And so we've agreed that if we're not changing anything, we're just gonna give verbal. So we're rejecting your 2 new articles, 29 on safety, and the 30 on miscellaneous. I would say on the,
Well, before we go past 28,
okay.
we had some changes we suggested here, because it says no later than April 1st. We have not hit that in the last 3 bargainings. For real reasons, like not knowing the budget, not knowing, like COVID was 1 year, not knowing the budget, a couple was another thing this year. And our ground rules are in violation of this technically. This is why I changed it to on or by or after or something like that. It's just so it gives us that flexibility. And with the budget fights that have been going on and all the political stuff that's going on in the Senate and the House up there, it seems like more flexibility is going to be a thing in the future. We're just not going to know these budgets till later.
That's what you're saying.
Yeah.
What,
talk about.
yeah, let me, hold on a second. So so I guess the difference between what we have and, so when I interpret our contract language, the current contract language is no later than April 1st, the district and union shall meet to negotiate a successor agreement. That doesn't necessarily mean negotiations start. I mean, that's how I interpret it.
Well, I mean, our practice is not that for sure, the last 3 bargainings that I've been here.
So whereas, I mean, I guess we can take a look at yours as far as negotiations of
Yeah.
a successor agreement shall begin on or after. I mean,
Yeah.
maybe it's the same thing. I
Yeah.
don't think that the current contract language requires us to start negotiating no later than, it just means we're gonna meet. So.
Well, this is
I don't know.
meet
Ron,
to
what do
negotiate,
you-
so.
What's been past practice?
Past practice, we always kind of met before.
Oh, okay.
Except for the last 3 years, last 3 bargainings, including this one.
I remember that with Andy and Danny.
Okay.
Before.
And I mean, I don't, I mean, I'm not sure what this
We're a
would
lot simpler
buy us.
back then.
Yeah, right. I'm not sure what it would buy us to go real late either. I mean,
Right.
it's just a function of necessity this go around, because we didn't know about the budget, and I mean, you didn't want to be putting a bunch of money out there without knowing what's happening, you know, so. I think that that's why we made the change. I just think it makes it clear.
As far as your, can I talk a little bit about miscellaneous?
Yeah, I was just gonna ask you to elaborate on 29 and 30, yeah.
So I think, well, we can maybe go in order. 29. I mean, some of this is all aspirational and would be, some of these things happen. But I think that when you start writing aspirational language into a contract, then that makes it subject to grievances and other things. And so that's why we have, a lot of this stuff comes from board policy, which, again, going back to our previous lengthy conversation about complaints and grievances and stuff like that, that this kind of language just opens the door towards more grievances when these are things that we strive to do already. So,
I would say to quote a wise man once told me, grievances, I like grievances because they help us to define the contract and understand what we're supposed to do.
yeah, but things that are.
Mr. Bush.
I might have said that. So, but things that are aspirational that I can't, that are really subjective, make a very, very tough to have in contract language when,
Well, I can respect that opinion. I would say that's why we would ask you to bring us a counter of something that you can live with, because we are looking to have a process to deal with this stuff without having to run to Boley. That's just it, I mean, for very much the same reasons that I gave before in our lengthy discussion, the more things we can deal with in-house between the 2 affected parties without the interference of a third party, I think is a win, I mean, we're obviously not going to do anything illegal, but having this stuff that we can sit down and resolve these things without having to go to that third party and, live with whatever they decide is the best for us, like we're errant children, I would prefer that, personally.
well, I guess the thing is that's, Bully is there for a reason, and that, if we're doing things that are going to lead to, I think that there's a reason why we don't have Bully complaints is because we're doing everything that's within the law. So, I do think
It's a plank to walk out on, because, who knows what's going out there sometimes, right? I mean, we can't know it all, but I would say that I see Bully as we cannot figure it out, and we go to them. They're our last ditch of the process, right? That's how I see them. People that don't see any process for dealing with a safety concern, it may be their first inclination to go to Bully. They sit down in the break room and they look at their little posting on the wall there, and they might say, this is happening, I need to talk to these people. They have no process other than that. Why would we not want to do that? I don't see the downside. If you get a grievance, it goes to, an arbitrator, let's say, okay? arbitrator might decide this, that, or the other, but bully can absolutely correct that too, if it violates the law, right? Somebody, if I was you, I would complain to bully, and they would, look at it and they could correct that. It's my understanding of how it works, because they have domain over that. But I'm hoping that the issue gets brought to the supervisor, first step, that it gets taken to formal grievance is not resolved, up to Scott to get it resolved before it ever get near an arbitration issue. Because usually if it's a safety concern, you guys will fix it, right? I mean, what's your alternative, right? So I don't see a downside here. The grievance boogeyman, I mean, I worked in UPS, 1,500 grievances were filed 1 year, me being a rep there. Okay, and I would say that was for a lot of reasons, but generally speaking, we still got through all of them and got them generally resolved. I don't think of one of those, in fact, none of those went to arbitration that year. But it was a lot of work for me, but the next year, it tailed down, it came down, it came down. You guys are nowhere near that, We get, since I've been here, we had 4 grievances, Dan, maybe? So I don't think that it's gonna be nearly the same kind of thing. But I do believe that giving that process to people, and if it doesn't work, then they can go to bully, great. But at least we did everything we could here to keep it within our group, people that have a vested interest in getting it working for the district or the chapter. And I've just seen a lot of things come from these outside groups in my career that have really made us have to live with things that are just not helpful. And maybe that's me being, Pollyannish about this, but I've definitely seen enough to be Pollyannish, I would say it that way. And I don't think it hurts you to have a safety article in your contract.
Do you have any contracts that have a safety article?
Oregon City, we have one in Central. I can't remember if we put it in Dallas last time or not. I think Lincoln County does too. Yeah. We got one in North San Diego. They just agreed to one in bargaining. They rewrote it with what they thought would be appropriate, and we agreed. So it was pretty simple there. But those are the ones off the top of my head. And I would say if you did a search with the 140 chapters out there, you'd find more. There's a lot of.
So you just got an agreement on safety in North San Diego?
Yes, like last week.
Awesome.
Yeah. I'll send it to you if you want.
That'd be great.
Yeah.
So on the miscellaneous one, I guess what I would say, that a large part of this, I'm not sure we'd agree to it, but it feels like this belongs in the discipline article. It just feels like this is, regarding discipline with the use of videos, equipment. So I think it really, if we're going to talk about the use of equipment for, that can be used in a disciplinary situation, it should go there versus having it live outside.
So I think there's one little piece that says it can't be used for surveillance, isn't it? I guess I can look at it. That might be helpful. I didn't think there was a ton in there about that, but maybe I got that wrong.
Well, you've got the opening sentence that talks about, it's a valuable, appropriate tool, however, it is not to be used to monitor employees. Well, so.
Did it say monitor or surveil?
Monitor.
Oh, well,
So,
okay.
That's not why we have it.
No, I know. You guys have
so-
been good coming to me even when you're using your drone, recording things. It's not that. I really am trying to put a process in the contract that we agree with, so you don't have to meet with me when you put a new camera up or do it. We just follow that, right? We don't have to bargain it every time. That was the intent there. The only piece that in there, the surveil and monitor, I guess it's about the same difference, is that we don't want people sitting there going like this and watching you while you work. That feels a bit heavy-handed. You record it anyway. So, this is a scenario that came up in another place where somebody was doing that. So, but, I guess we could talk about putting it in other places, but it's just, like I said, really I'm trying to give you something that's, so we don't have to bargain every time. You're going to build a new school soon, right? If your bond goes through, right? You're going to probably want to put cameras in there. Do we need to sit down and bargain it, or can we just go with this language and do that, That's really the intent. So.
And as far as, adding, I know you talked about wanting to,
That's right.
bargaining sessions. I would say I would not want that. I would want that part of the ground rules. Things change.
Which thing? The video?
Yeah.
Oh, okay.
Like SFEA did not want them handled this year. I'm not sure why they didn't want to do that this go around. You might feel the same way. The fact that we do ground rules every year, or every time, not every year, here every time. I think we should just leave it a part of the ground rule process.
Well, it's up to you, I guess, to think that. I mean, you made a lot of comments today about transparency and being on the video, so it seems a little contrary to that. But I would say that this is what the leadership and what the folks have told me. And I think I've left it fairly neutral, so it's not a specific medium. It's just digital and video agreed to by the two, because things do change. I mean, this had all been VCRs before, right? And now it's in CDs, and now it's all streaming, right? So the point of putting it in there is just so we don't have to deal with it every ground rules. It's just an expectation. If people wanted to take it out, they would take it out of bargaining, right? I mean, and I can't speak to the teachers because I don't represent them. And besides, you guys like us better anyway, right? Oh, whoops, that's on the tape, isn't it? No comment.
No comment.
So I'm just teasing. But anyway, but it just seems to me that it's a level of transparency that, as you said earlier, that is helpful for people to understand, and the community too. So.
All right, well, I think that gets us to we put, I guess the job classification groupings, we put, do we want to have a discussion about that? How do we want to handle that addendum?
Yeah, I mean, we've
got a lot of work to do still.
Yeah, no, we do, and that's a great question. I don't know the answer. I'll have to talk to the team here. I mean, I think probably, it's just a work session, but I don't know if you want that or not for that, but.
Well, we have that work session scheduled tentatively. Does that work for you guys? It
works for me in advance. I'll have to talk to our third person.
So the 15th?
Yeah. From 2 to 4:30?
2:30 to 4.
2:30 to 4.
Yeah.
And maybe if we are doing well with that, we could maybe even extend that. I'm going to leave my afternoon open, so if there's a few other things we want to talk about, we can. That's up to you though, but that's what I'm going to do. So.
I think maybe our team can caucus about that and figure out how much
Sure.
we want to, how much time we want to give to that. I think in looking at the articles that are now in I think with a little bit of work, we could get reclassification back to you. And that's how I would prioritize our time. So
Yeah.
maybe we should caucus.
Okay.
So in Article 13, we kind of broke out B because it seemed like it was getting to becoming a long paragraph, and it seemed like it was sort of separated between selection for interviews and then selected for the position or not. And so we counter-proposed on your seniority piece where if the district determines more than 3 current employees are equally qualified, interviews will be awarded based on seniority. So if we have, they've met the minimum qualifications, and then, we look at the candidates and we go, yeah, I can't tell who's more qualified, then they'll be determined on seniority. So,
Okay.
and then we went ahead and agreed with your addition there that employees shall be notified if they are not selected. So we added that language, and then the rest of it's the same. We just kind of separated that.
Okay.
And then we counter-proposed on the temporary piece, the union shall be notified within 5 working days of the temporary assignment. So we kind of just put a time frame there.
Okay.
We agreed with your, in Roman numeral 5D, Roman numeral 5, is that we eliminated the call. They have to email the Human Resources Department.
Okay.
And then our counter-proposal on fingerprinting is if the candidate is hired, the district shall reimburse the cost of fingerprinting upon successful completion of the probationary period.
Do we still need to see Article 3 in there?
We had that conversation. We
did.
thought we would leave it in there.
About do we need to clarify anything on that reimbursement, that it's the payroll after we talked, I think we could go either way, but it's referenced in salary also. So we either need to cut it from 3 and only leave it here, because I would never want to have something that doesn't talk, right?
Sure, doesn't
Yeah.
match up, yeah. Okay.
So we're open to that if we cut it from
Okay,
salary,
all right.
which almost seems like it might make more sense not to be in that order.
Right.
Wage, excuse me, and compensation. Salary.
Well, I think we're pretty close on this one. I mean, obviously, we'll need to talk for a sec, but I think we're real close on that one now. Getting closer anyway. And you want to go with 15?
Yep. So on this one, what we did was took a look at the language that you presented and tried to incorporate it into existing language. So for instance, your proposal said that there'd be a notification. So we added upon receipt of a reclassification request, an email would be sent and copied with the union president. And then we liked your language there about at the time of the meeting, the requesting party shall have the responsibility. So we added that language into what happens at that meeting. And then you had some language in there that if the parties didn't agree, I think you had 2 days, we said 5, that said that they had to make a recommendation to the superintendent within 5 days. So as far as the proposal regarding the salary change, we felt that belongs in the compensation article, and so we will bring that forth in our compensation proposal.
Okay.
So,
Move to comp.
yes.
Got it. All right.
Yeah, so you can write that down, it's on recording, but it will be in the salary compensation article.
More or less writing it down, so I remember not to include it back in our calendar if we have to. Okay, yeah, well, I think.
So I know we're right at 5 o'clock, so you probably don't have time to
We didn't-
caucus to
Well-
TA these or not.
Yeah,
since it
I
feels
don't
like
think we're there on this one. I think
Okay.
we are getting closer, but
Yeah.
this one's real close. So what I'll do is, we probably will do a quick caucus to talk about this one. And if we're good, I'll let you know before we
Okay.
bounce out of here. And it won't be in the recording, but we'll have it for next time.
Okay.
Okay.
Will we be TAing Article 8?
The grammatical changes, yeah. I believe so.
Okay, you got 2 signed
I
already?
haven't signed them yet.
Okay.
I wasn't sure if you had 3 already signed.
Yes,
or-
no, I don't.
Okay. All right, well, thank you all for your time. It was a great discussion, and I guess we'll go off record.